Yes, it is a lot. My lord, I am praying for my lord indulgence in allowing us for putting of an artistic method. My lord, it is not accepted. Regarding my tender matter, we have the high spread.
My lord, I am praying for listing a matter, my lord. In this case, my lord, some articles has been seized by the police, my lord. Some articles of the petitioner has been seized by the police, my lord, without giving any, my lord, seizure list. So, my lord, next week, anything.
It will come up for what?
Admission, my lord. On, my lord, 24, 24, 11, 23, my lord, not 12.
What is the urgency?
Articles has been seized, my lord.
Huh?
Some articles has been seized, my lord.
By the
Police, my
second.
Three matters, Lordship, for listing, Lord. Petitioners are the same. One needs to be withdrawn because we'll go for arbitration, and two others are tagged together. Lordship, it is listed on Monday, Lord. If
Monday, why? What is the urgency?
31st, Lordship, there is a holiday. Madam,
Second.
Lord, much of.
May I pray, Lordship? Lordship, with the consent of the petitioner's file, Lordship, I beg to mention item number 7, Lordship. Lordship, in this matter, on 30/12/2023, we have done the joint verification, Lordship, but the report could not be filed today, Lordship, because the concerned secretary is on medical leave, Lordship. Therefore, Lordship, 2 weeks time may be granted to file the report, Lordship. Joint verification
You
is
have
already
taken the
done.
permission.
Yes, we have taken the
Consent.
consent of petitioner.
The request of the learned counsel for the respondent.
Yes, KAC, Lord, Karbi Anglong.
AAHC. The matter stands on again. 6th of February.
Bibliography.
May it to Lordship, my lord, the item number 50, my lord. On the other side, my lord, to read it Islam, it is the case, but duty is serious illness, my lord, not come. Cannot report, my lord, your lordship one time.
Which one?
Item 6,
Is it 2015 matter?
my
It
lord,
doesn't look nice.
matter, my lord. Suddenly, my lord, is not problem to read it Islam, my
You do it.
lord, say now morning of my lord, I thought that,
So I will also help you out.
my lord, my lord. Otherwise, my lord, I am, my lord.
We'll see what is to be done. Next.
My lord, this matter for listing, my lord. The matter regarding the salary. So, Akhil Bharatiya Safai Mazdoor Sangha versus Oil India.
Matter pertains to
salary.
salary. Salary, what am I good to do? I have no business with salary. Salary is some other code. Salary of what salary?
Actually, they got an order from a particular code, and this order has been challenged by all the
No, salary is a bench 4-5 matter. Can't be. Salary from government. Salary from whom?
salary from Oil India.
You have not received the salary. We'll have it on 7th of February.
Maybe. Lordship, in item number 1, my lord. Day before yesterday, Union of India filed their affidavit. We need to file a reply, and moreover, because senior concern Mr. Sayabala is not.
Let us see when the matter reaches.
For it.
Mr. Bora, just wait for some time. Let me complete the motions. I have 2 motions. Just 2 more.
Number 9, proposal.
Also, ma'am, a similar order. Yes, sir. The matter
Same
will be
order.
taken along with that.
কালি যোনটো order আছিল ন এটা order এটা দিছিল ন
WPC 228.
এইটোৰ orderটোৰ লগত same. I have given you I say pending the last I have made a little bit of changes out here that pending disposal it shall not be a bar on the part of the respondent to make the demarcation.
Lordship.
And also I have added that the respondents would be at liberty to file applications seeking modification or alteration.
Lord,
Because once, if you make a demarcation, you can very well file an application.
my lord, for
Because the
modification.
only stay, why I have granted the stay is because of the fact that till a demarcation is not done, it is not possible for doing it. So his rights needs to be protected till then.
Lordship. Deeply obliged, my lord.
Only fishery name কি আছে? ওজাবরা my lord. The fishery we have.
That they will change. সেই নামটো বেলেগ হ'ব। আগতে কাৰৈ মীন মহল আছিল, এতিয়া নামটো বেলেগ হ'ব, and his and your contention will remain the same,
Same.
that the MAC does not have the authority on the
Authority.
basis that the government has not.
Transfer the subject.
And the question out here which arises
18.
is privacy from section 18. It
18.
reveals that the MAC has it within its jurisdiction.
Jurisdiction. Lordship, I deeply obliged, my lord.
Nepito. The matter pardon regarding the settlement of a ceremony. My lord, the 14 and 15 Neharian years, my lord, for a settlement issued on 21/9 for 20 years. The petitioner along with the other participant in the process, and petitioner is the,
Now you are challenging this 3012.
yes, my.
Now, has it been extended?
I don't
Because
know
on the last occasion, I extended till 22nd, 5 o'clock,
yes, I don't
because it was closed. By 22nd morning, it was closed.
Yes.
And here was on the holiday, half the holiday. Now, has it been extended?
I don't have any information. It was supposed.
Mr. S.R.
know
Burra
information.
was appearing
No,
for the deputy commissioner in that
Yes.
matter.
It's not, no,
Yes, what is your case?
my lord,
You
I
are
am-
number which one?
I am the highest valid bidder. Second, my lord.
Highest value. Highest value bid did not quoted, was not in terms with
Quoted,
48.
I have quoted. Finally, kindly see my lord test 7 months. 7. All the bidders I have quoted. All bidder Pramod Ishak, my lord. Test 7. And
Pradeep Biswas.
yes, my lord, he was defective.
Who is Pradeep Biswas?
Pradeep Ishak is first bidder. But he was defective.
Highest bidder. He
Yes,
is the highest bidder.
yes, but he was defective, my lord. And I am the second bidder. And my lord, the last occasion, my lord, they,
So your bid has been rightly cancelled.
no, my lord, third bidder was cancelled. Pramod Chandra. Pramod Chandra.
No, how can you be the number 2? Pradeep Biswas was the number 1.
No, my lord. Actually, my lord, Pramod Chandra, that was third bidder. This order was, my lord, wrongly mentioned, my lord.
Hmm.
Wrongly mentioned, my lord. Pramod was third bidder. Kindly page 21, they mentioned the Pramod was the highest bidder. But in fact, my lord, Pramod is a third bidder. Page 21, my lord. In order,
Where is the, yes.
page 21, my lord.
Hmm.
Yeah. But it is the third highest bidder.
Pramod Chandra Biswas.
Yes, Lord.
He is the third.
Yes, my lord. But yes, on order sheet is reflected high bidder. I am the highest bidder.
In the order sheet, it was highest bidder was the Pramod Chandra Das.
So, why should we take note of yours? Yours is not in terms with 48. Rule 48 categorically says that the first year, and there will be consistently increased by 10%. See your bid.
Down my whole tender process was.
Absolutely. Everybody's is like this. Well, see number 1, 14 lakhs, and the last one is 41 lakhs. Number 3, 13 lakhs, and then the last one is 46 lakhs. What is all this?
My lord, my bidder is similar, my lord.
Your bid is completely wrong. Kindly see Rule 48. Rule 48 categorically mentions that first year and then every year it will be increased by 10%. Where is it? See. Isn't it?
Yes. My lord. In tender process, it was not mentioned, my lord.
Is it
That's why
mentioned, required to be mentioned when the rule says so?
constructive notice.
Have you looked into rule, rule 48, or just filed it for the sake of filing it?
Case of the belated
The last portion of 48.
Okay.
48.3 is not there, but after 48.2, then you see one line out there. Have you got it, Mr. Sharma?
Yeah, place value will be fixed for a period at a timeline with 10% annual increase.
Huh?
At a lease value will be fixed for a period of 7 years at a time with 10% annual increase.
So, where is your annual increase of 10%?
And when did
And DC had cancelled it on the ground that all the other bidders were not quoting as per, they were, see the reason out there. The reason out here is, all the bidders. The bidders, finally see here, whereas the minimum rate is so and so, whereas instead of submitting the bid as per 48 a month, bidders quoted differential and arbitrary annual rates for different years. And your case is you did not quote at all additional. You consistently became 19,20,000. You should have given 10% extra, or was it difficult to calculate?
other bidder also, my lord, that's not 10%, my lord.
That's the reason.
My lord, serial number 3, serial number
No,
4.
no, no. They have made the mistake. You see, earlier, serial number 3, they made all these 13 lakhs every year for 5 years, and
Serial number 3 also not mentioned, my lord.
huh?
Serial number 3 also, my lord.
Understood. The serial number 3 was also wrong because 46 lakhs couldn't have been given.
Only on that part, my lord, Pradeep Vishwas is other all the
Pradeep Biswas also, kindly see this. 14 lakhs, 15 lakhs, 16 lakhs, 17 lakhs, 18 lakhs, then 40 lakhs and 41 lakhs. This is absolutely absorbent. After 18 lakhs, how can you go to not double, more than double? So what is wrong? In fact, if I had got this particular thing on that day, I would have dismissed that writ petition itself. However, I have not passed any interim out there. I've said that, okay, he may participate as per the new tender.
Yeah.
That is why I asked you as to whether you have participated in the new tender.
as per my telephonic info, they are participating.
Very well. Now withdraw. No case.
Get it pending, my lord, the father of the the record will be verified, my lord, whether the my lord, the
No,
statement, my lord.
are you saying
As per my
the
telephonic info,
no? Are you saying that the materials which you have put out there in page number 7 and 8 are wrong?
is suspicious. No, my lord,
It is right.
as per my information.
No,
that is right,
Mr. Counsel,
Yes,
let us make it very simple. Are you saying that the materials at page number 7 and 8 and 9 are wrong?
Or
Then
suspicious.
what is wrong with the order?
Or suspicious.
Huh?
Or suspicious. Wrong or suspicious.
He wants to use the word. I am not doing it. But this is very much clear. You want a notice? I can very well issue a notice to show it that another repetition is pending in the High Court.
That will be fine for his client, Lord.
Huh?
That will be fine for his client.
That is the only thing. Otherwise, you don't have any case. And you have participated. Be happy with the participation. Now do it as per 48.3.
Yes, Lord.
No
Lordship
case.
may I pray by giving a reasoning, Lordship may dispose of the petition.
Interim.
Dispose of the petition, Lordship. By dismiss it
Dispose of the petition.
by giving that reason, Lordship. It will be helpful for him also. If Lordship give this reason that all the readers are that here, Lordship.
You want that if I give these reasons, the other repetition also becomes infected. Better, Mr. Counsel, you withdraw. Because otherwise you are going to affect whose name? Who was the earlier one who filed?
Earlier, my lord, Pramod Chandra Das and
Now, one case is of Pradeep Biswas, one Pramod Chandra Das.
Pramod Chandra Das.
But Pramod Chandra Das case is only limited
Yes,
to
my lord, that is limited.
what you call
Participation.
Partition.
no, the amount being taken away. There is a forfeiture amount which
And
has been
again,
done.
debarring him to appear.
So that is the only thing on which
And
this is
next,
there.
my lord, November.
And there, the only ground on which it has been done is that power the deputy commissioner has not been delegated.
Yeah.
That is on a different one. But this is on a different aspect.
Yes.
And today, the AF, what you call the fishery department, your fishery?
Yeah, the Fishery Department.
Fishery department now is supporting the DC.
Today.
That day he was not. He was
Yes.
saying that the DC deputy commissioner had no business to do that.
Right. Yes, lord.
So what to do? Dismiss.
Dismiss with reason, lord. Dismiss with reason.
Obviously, dismiss with reason he wants, so that your other friend case also becomes bad.
Actually, on that part, my lord, I am the valid bidder, my lord. That's not opportunity to-
Understood, but how can you be valid bidder when it is not as per Rule 48?
But in tender, that part was not mentioned. my lord.
It is required to be mentioned in the tender when the rule says so.
My lord, tender part, it is in tender notice, my lord.
Mr.
40%.
Counsel, we expect something better from you. Are you going to say all these things when the rules say something? You are saying that the tender does not mention all these things. Doesn't look nice. Not befitting your stature. So what to do? Hello. Enough.
My lord,
I'll dismiss it now.
liberty to withdraw, my-
Liberty for what?
I will withdraw, my lord.
Withdraw. Yeah, better. The learned counsel appearing on behalf of the petitioner submits
tender
that
they are
as the
satisfied, my lord.
petitioner had submitted his tender pursuant to the fresh tender notice dated 30/12/2023, he would not like to press the instant writ petition. So taking into account the above, the instant writ petition stands closed on withdrawal.
Highly obliged, lord.
Yes, Mr. Akidip Chaudhary.
Lordship, I've been instructed to appear.
Very well.
Lordship was on the proceeds of crime as per section 2 LU
2-1 you.
21. Retrospective.
Before my learned friend starts my, yes, I want to keep that particular judgment.
Which one?
That one, the last day, my lord, the appellate tribunal which is decoted the Supreme Court, that I have found out. This is a 3 judges judgment, my lord. Lordship kindly see the paragraph 9, 10, and 11. 11 is the now regions has to be communicated as per the 3 judges sentence.
Understood, but this judgment is doesn't hold water now. But anyways, you take your seat. Let me ask him on
But
another.
the 3 judgment,
His judgment is no longer good because there are many other judgments. In
but these
fact, not only that, I'm saying forget about this. This is a judgment of 3 judges.
Yes.
A 5 judges judgment is their constitution bench judgment, which has not been taken into account by the Supreme Court in this judgment. It's clear from that. You see Satyanarayana Murthy, then you see K. Matthews, that judgment out there categorically says that the question does not arise of giving the reason.
Decision has been made.
But this was not, if it is not being taken note of, it becomes a per incurium judgment. A constitution bench
Well,
judgment
no
having.
one has declared it per incurium.
I need not, I may not totally not look into it for you to put it up before the Supreme Court. But when the constitution bench of the Supreme Court says it is not required at all, no, it's not. Let us look it. Yes.
But which may I know the constitution? We have it in summer. No problem. I'll take it from. Let him proceed, my lord.
S. Narayanappa versus CIT 1967, 63 ITR 2000, ITR 2019. Then there is another one, K.S. Rashid and Sons, and another versus the income tax officer, and another AIR 1964
I got
SC
it.
1190.
Yes, but it has been distinguished by this judgment, paragraph 60. That's right. Paragraph 60.
Yeah.
Okay, ma'am.
Ada?
Para 16.
Kindly see how
That-
it
that-
has been
Yes,
distinguished.
yes. That
So
I have
therefore,
to
this would not apply.
because this is also very new for me to the IT.
No,
That's why
it is on the question of there is a therefore I am saying, if you are challenging on the existence of the reasons to believe or reasons, then in that regard, it is a case of jurisdiction. But if you are considering challenging on the sufficiency, then it is not a question of jurisdiction. However, if it is a proceedings, just for example, you in a proceedings under 42, you raise this issue, then obviously it is on the sufficiency which the appellate or the adjudicating authority needs to be looked.
Yes.
And therefore, then the reasons are to be given to you. So that is why it is. That is the difference.
yes. But the only thing is that the in the
But
initial
anyway, you
stage-
take your seat. Let
Yes,
me ask
yes.
him a few questions. Yes.
Now, if I may, Lordship,
Mr. Architect, you are new out here. Let me tell you. I've looked into the reason. There's no question that there is no reason. There are reasons. The submission of the Learned Council out here is Section 2(1)(u) defines what is the proceeds of a crime. There are 3 limbs out there. The first limb is connected as regards the schedule offense. The second is of the value of the property in respect which is obtained from a schedule offense. And the third is if any property which is obtained by a schedule offense is taken out of India, then in that case, any other property which is lying in India.
Lordship, just small. The third limb is not only confined to outside. If I may.
To me, PMLA. Yes.
Just a small question. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken.
Where such property has to be again property derived from a schedule offense.
Yes, Lordship. Yes. Or where such property is taken or held outside the country, then the property equivalent to the property held in the country. Now, let us see how the Supreme Court has explained it. In this regard, may I take your Lordship to paragraph 68?
What is this?
This is Vijay Madan Lal. And thereafter, I will take your Lordship to a few more paragraphs.
You have the SCC online of this? No.
I am not carrying it, Lordship, but this is the Supreme Court printout.
Anyway, this is paragraph 68 out here corresponds to paragraph 76 in SCC online. And this is the argument.
Lordship.
This is the argument which is again what I am saying, which is what they are saying to the effect. Now the answer to that can be found out here. I don't know what is the page out here, but in the SCC online is paragraph number 250, 251 and 252.
It starts with what? Okay. Deliver about Supreme Court. Okay. No, Supreme Court.
Very difficult to find. It's such a
Lordship,
big
this,
judgment.
different.
Yes. Where the Supreme Court has dealt with that particular in any judgment? Yes, paragraph 30 of your, the one which you have given. That is paragraph number 250.
Paragraph 30.
30. You got it?
Yes, Lordship.
Yes. The other relevant definition.
Yes. Lordship, may I?
And the submission was, kindly see the submission which was made. Yes, kindly come to page 97 of your paper book, the paper you have given. This is the submission which was made at Roman 2 and Roman 3. This corresponds to paragraph number 76 of that bit,
FTC online 9
9 to 9.
20.
The contention is referred in paragraph number 76
Yes.
of the jet, which is corresponds to page 97 of your.
Yes.
And then the answer could be seen at paragraph number 30, 29 and 30 onwards. The Supreme Court deals with what is the proceeds of crime. And more particularly at paragraph number 33, the Supreme Court holds that there has to be a very strict interpretation to the term of the proceeds of the crime. But the answer to what is here can be found in the recent judgment of Justice Kokar in the case of Pavana Dipur versus Director of Enforcement 2023 SCC Online 1586. Here there were various issues. One of the issues out there on which it was interfered with as to whether merely by putting section 120 in the schedule offense, can you cover all other offenses? Because 120 is for criminal conspiracy. The Supreme Court said no. 120 has to be related to an offense which is already there in the schedule. But interestingly, here there were two properties. The first property was acquired prior to the act coming into force.
Yeah.
And the second property was acquired subsequent. Now the Supreme Court said out here, as regards the second property, this is a question of evidence, we cannot look into it. But the first property having been acquired earlier, that cannot be a part of a proceeds of a crime.
Lordship.
So that is therefore the issue out here. Now, can it be so? Kindly see, if you have this judgment, more particularly here, I'll give it. Kindly come to paragraph 19 here. It to the effect. In fact, this thing makes it more clear because you see, if you see the another judgment of the Supreme Court in the case of Y. Balaji. Have you gone through that?
Not what.
Okay. Now you see, this is another important case that is pertaining to this TN minister which have been going on. The Supreme Court takes note of that 2(1)(u) you have to read it with Section 3. Section 3 has the exact words of the Supreme Court is the Section 3 has 3 P's. First is person, second is process or activity, and the number 3 is the product. As regards the person, there is no problem because it has been said clearly that who would be. Process and activity, there is no problem. Possession, use, acquisition, and the activity or the product is the proceeds
That
of
has
the
to be
crime.
the outcome of the.
No, that is the proceeds of the crime. So the third P is the proceeds of the crime. Now, which is the product. Now, product, if it is the proceeds of the crime to make it a offense, can it be an offense when that was never, the act was never there when the acquisition was made?
Gosh.
Therefore, if it cannot be a proceed of the crime, then would it be proper on the part of them to take that particular property as a disproportionate asset or take the value of that property as a disproportionate asset in the provisional attachment order? Because you have arrived at the provisional attachment order by taking that property which was never a part of the property coming within the ambit of Section 3.
Was acquired before.
It was acquired earlier. So, therefore, whether the reasons to believe, because your problem out here, why you incorporated this property of 1997 is on for the purpose that 60 lakhs was there for one property. Another property, another 38 or 40 lakhs are there. The remaining is this 58 lakh property. If you add it, then it becomes 142. Now, to come to 142, has it been rightly done, taking into account the property which was not there at that point of time?
I get your question.
And would that be then the reasons to believe are there or not? You may have a reason to believe as regards the other two properties, very well. But for this property, do you have the reasons? That is my question. Is that not your submission?
Yes. I will need some accommodation to reply my on that
because if you see,
yes,
more particularly your judgment which you are referring
Yes.
to,
Yes.
kindly see Vijay Madanlal.
Yes.
Kindly see this particular paragraph of the judgment. Kindly come to paragraph number 30, which we are referring at page
Yes.
251.
Yes.
The other relevant definition is proceeds of the crime in section 2(1)(u) of the Act 2002 Act. The definition is common to all actions under the Act, namely attachment, adjudication, confiscation being civil in nature, as well as the prosecution or criminal action. The original provision prior to the amendment under the Finance Act 2015 took within its sweep any property mentioned in 2(1)(v), that's property definition.
Yes.
Derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense mentioned in 2(1)(y), read with the schedule to the Act, or the value of any such property. By the Finance Act 2020, it further included such property being proceeds of the crime which is taken or held outside the country. Then the property equivalent in value held within the country And by further amendment, it also added property which is abroad. So tomorrow the state has the government of India has certain treaty with the UAE that they can very well attach a property out there in UAE. Then in that case, you can do in respect of any problem if it is there in London. By further amendment to so and so, explanation has been added, which is obviously a clarificatory amendment. This is evident from the plain language of the inserted explanation itself. The fact that it also includes any property which may directly or indirectly be derived as a result of any criminal activity relatable to the schedule offense does not transcend beyond the original provision. In that, the word relating to used in the main provision is present participle to the word relate, and the word relatable is only an adjective. The thrust of the original provision itself is to indicate that any property is derived or obtained directly or indirectly as a result of criminal activity concerning the schedule offense, the same be regarded as the crime. In other words, property is whatever mentioned in 1B is or can be linked to a criminal activity relating to or related to the schedule offense must be regarded as proceeds of the crime for the purpose of the Act of 2002. It must follow that the explanation inserted in 2008 is barely clarification and reinstatement of the position emerging from the principal provision. The proceeds of the crime being the core, being the core of the ingredients constituting the offense of money laundering, that expression needs to be construed strictly. In that, all properties covered and attached by the investigating authority in connection with a criminal activity relating to a schedule offense under the general law cannot be regarded as the proceeds of crime. There may be cases where the property involved in the commission of a schedule offense attached by the year dealing with that offense cannot be wholly or partly regarded as proceeds of crime within the meaning of section 21U, so long as the whole or some of the portion of the property have been derived or obtained by any person as a result of a criminal activity relating to the stated schedule offense. Now, just for example, if you see the other judgment of Justice Oka, which I was referring to, there a very nice definition has been given. Yes, a criminal activity happens for the purpose of in connection with a schedule offense. By A, does it? Now, this property, this B does not know anything about that. But B has been given this particular property, you kindly hide it. He has nothing to do with the criminal activity, but it has relatable to that. That is why it becomes the proceeds of the crime and it becomes a money laundering, becomes an activity of money. To be a proceed, therefore, the property must be derived or obtained directly or indirectly as a result of a criminal activity relating to that. To put it differently, the vehicle used in commission of a schedule offense may be attached as a property in the concerned case crime. It may still not be proceeds of a crime within the meaning of so and so. Similarly, possession of an unaccounted property acquired by legal means may be actionable for tax violation, yet will not be regarded as a proceeds of crime unless the concerned tax legislation prescribes such violation as an offense under so and so. So till it is not being made. So as of now, he may have a problem as regards a disproportionate asset in respect to the property of 1997 under the income tax laws. He may have. He may also have a problem as regards that under the Prevention of Corruption Act as it stood then. But for the purpose of this, it becomes very difficult to hold it. For being regarded as a proceed of a crime, the property associated with the schedule offense must have been derived or obtained by a person as a result of criminal activity relating to the concerned schedule offense. This distinction must be borne in mind while reckoning any property referred to in the schedule offense as proceeds of the crime for the purpose of 2002 Act. Dealing with the proceeds of the crime by way of any process or activity constitutes offense of money laundering under we noted, and it's okay. They're in the explanation and all these things. But this is the, kindly come to paragraph 33. Tersely put, it is only such property which is derived or obtained directly or indirectly as a result of the criminal activity relating to a scheduled offense can be regarded as a proceeds of crime. The authority under the Act cannot resort to action against any person on an assumption that the property recovered by them must be proceeds of crime and that a scheduled offense has been, unless the same is registered with the jurisdictional police or pending inquiry by any of the complaint before the. For the expression derived or obtained is indicative of the criminal activity related to a scheduled offense already accomplished. Similarly, in the event of the person named in the criminal activity relating to a scheduled offense is finally absolved by a competent court or so on. Now, this aspect of the matter has also been explained by the Supreme Court in this judgment. Why Balaji? If you see this was in fact another submission which was made. You have this judgment 2020 SCC online XC 646. No.
No.
In fact, the submission made therein was this. The common theme of the song of the learned counsel for the accused is that mere registration of an affair. This is on the basis of this. This is how the Supreme Court thinks. Is that mere registration of an affair for predicate affair, even if it is a schedule, is not sufficient for the ED to register an information report and summon anyone. According to the learned counsel, the commission of the schedule offense should have been generated proceeds of the crime, and those proceeds of the crime should have been laundered by someone for the ED to step in. Going a step further, it was contended by the learned senior counsel that the ED should first identify some properties as representing the proceeds of the crime before an information report is registered. Supreme Court said these contentions, in our opinion, if accepted, would amount to putting the cart before the horse. Unfortunately for the accused, this is not the act. And it went on all these things. But the question, therefore, is this property, in this case, for the property in 1997, it was not a schedule offense. If it is not a schedule offense, can you bring within it? And then wouldn't it touch on the entire exercise of having the reasons to believe?
Okay. The face of it, Lordship, if the amendment has come along. The schedule. Naturally, it will not come in.
Now, that is one.
Yes.
The moment it does not come in, you must have seen the reasons to believe. Now, reasons to believe holds it, says that this person concerned has been doing all these things from 1986, misappropriating it. But from 1986, it does not become a case of money laundering because the Money Laundering Act was not brought in. It only came in 2002. But the Prevention of Corruption Act was brought within the fold as per paragraph 8 only in 2009. So under such circumstances, if you are alleging as regards the civil offense which are there, could you have brought it back? No. Then under such circumstances, do you have any reasons to believe as regards the 97 property? You answer to me on the next day on the question of can these reasons to the order be the reasons to believe which is there can be segregated, or they can be it could be partly severed, by which the bad part can be removed and the good part remains.
Right.
Otherwise, the entire thing goes.
On the face of it, but let me have some.
No, can it be severed?
I will look at it.
if it can be severed by keeping the good part and not touching on by setting aside the bad part, then it is okay. But otherwise, shouldn't it be the entire exercise becomes bad? You may very well take up again a fresh action for provisional attachment as regards the other two properties. There's no quarrel with that. That power is already there. But the question therefore is
Whether this,
whether it can be severed.
Yeah.
Or because whether the reasons to believe which is there has to be taken in the touchstone of the entire thing, or only a part of it is bad, it's okay, but remaining remains.
I get it.
Because then your provisional attachment order has to further include furthermore properties, which are there in 1 to 20. But there are some 6, 8, and 9 which are there, which can be very well brought in, maybe less. But on the other hand, if you can't bring in this 58 lakhs property, then automatically the disproportionate assets which you held as 1 crore 42 would come down by 58. And that would suffice you for the other.
Then again, there would be a question whether
Hmm?
at this stage,
No, then also you can do it. But if, therefore I'm saying, if you see, just let's see that, kindly come to your notice, I'll show you how it. Kindly come to page 40 of their
yes,
writ petition. You see, page 40 is the list of various properties.
Lordship,
These are all 20 properties. The value is 2 crores 19 lakhs.
Lordship.
Now you say, whereas upon investigation, 7, it has been found that in the name of Iman, the scrutiny, and where it is seen that the total sum of rupees 3 crores was deposited in the bank account during this period. So this is 3 crores. Then kindly come to paragraph 8. From the introductory computation of income and expenditure prevailed by the vigilance so-and-so, the total investment of so-and-so and his family in the immovable properties, land plus building, is 1 crore 95. He is having movable assets to the tune of 31 lakhs, and the total investment of his is rupees 52 lakhs. The total income was calculated as 139, and the grand total of his family income was 217. Whereas the total expenditure of the accused and his family was calculated at 360. Hence, the estimated net disproportionate is 142. This is the basis on which you have the reasons to believe. Now, this amount includes that 58 lakhs, which is at page 40.
Yes.
Now, automatically, if 58 comes down, 58 comes down, the disproportionate asset amount will come down. Obviously, you can very well attach the other things which is there. But the question is whether the entire action becomes bad on a ground of non-application of mine. So, when? You want to have a very peaceful Republic Day?
Tuesday or any day after the 2nd.
Okay, Tuesday. Nothing more. That is it. You just come up on that point.
Yes.
Well, I'll be out of station, my lord. The next one, February, my lord.
Yeah.
February 1st, 2nd, anything.
First, second, Lordship, I have something.
Then-
The next week,
It will be on first. Mr. Bora, I have already heard you. This is the only point.
yes, Lordship, let it be on Tuesday, Lordship.
Let
First, I
it
will
be on?
on Tuesday. First, I will be
Okay,
Lordship.
on 30th. I'll have it on 30th. Don't worry. You
I'll
see,
be out of station.
no, understood. But anyways, whatever he says out there, if anything else, if he can make out a better case, that no, yeah, those earlier points can be taken out. Otherwise, you have already submitted. And I've already submitted on your behalf also.
I'm obliged, my lord.
So under such circumstances, let us see what he comes up with this thing. And it becomes more pressure to Mr. Arkadev Chaudhary to have it on Tuesday.
only my absence should not increase my disproportionate.
No.
Oblige, right?
No, if it is these 4 things, then I'll fix it on Thursday. Then I'll give you a chance.
Oblige.
But otherwise, the hearing being, matter having been heard, Mr. Mr. R.K. Dev Chaudhary, the learned Deputy Solicitor General of India, appearing on behalf of the Enforcement Directorate, submits that he would require some further time to address his arguments on the question as regards arguments. Hearing being inconclusive, list the matter again on 31/2024 at the top of the list.
Oblige.
Worship, the records will be here.
The records, you bring it again. I'm not taking the record.
Also, like, so whatever has come from your lot, I did not get it from my plans.
No, the records are these. There's no quarrel with
now,
that.
Now things are clear.
But
Worship.
only
I'm-
thing is you have to catch hold of this. Now, the thing is, can it be severed? Or the entire thing? And the disproportionate assets wouldn't it come down if it is not the proceeds of the crime? And if it comes down by 58 lakhs, then automatically 1 crore 58, you have the other 2 properties which will cover.
Flush.
And come up with this thing, next time SCC online becomes it becomes easier for us to be in tandem.
I will.
Otherwise, it becomes difficult for this court to keep on searching.
I number 1 for admission.
Yes, affidavit filed.
Yes, my lord. Yes, my lord.
Well,
Day before yesterday. Union of.
No,
my lord, on Monday, my lord. 22nd.
you have filed there.
Yes, yes.
Okay. Now what is it? Why did I file affidavit for this amount?
Yes.
You filed it yesterday. And what about the state?
No, my lord, we filed it on 22nd, my lord,
The day before.
on Monday.
And you?
It has been covered here. I have seen the affidavit that the stand will be safe, that the process that has been followed, that has explained how the amount was reduced.
That affidavit, however, is not on record. And you want 1 week's time to file.
My lord.
Mr. M.R. Adhikari, the Learned Standing Counsel, appearing on behalf of the Learned CGS,
CGC.
submits that the affidavit have been filed by the Union of India.
Well.
Mr. A. Kolita, the Learned Standing Counsel, appearing on behalf of the Industries Department, submits that the Industries Department would not file any affidavit.
We support this letter because that has been covered. Everything, the process.
And he submits that the affidavit so filed by the Union of India duly addresses the points which the Industries Department would like to also rely upon. So, Mr. Your name?
HK Sharma. HK Sharma.
H.K. Sharma, appearing on behalf of the petitioner, request for a accommodation for a month, for 1 week for filing the reply. So, taking into account the writ petition is of the year 2015, the matter stands adjourned to be listed again on 13th of February 2024. Affidavit in reply to filed by 9th of February. Full stop. the registry shall also bring on record the affidavit which has been already filed by the Union of India.
Much.
I number 2 for hearing.
First of all, I seek apology because my senior due to some personal difficulty could not reach court on time.
Hmm?
It's coming. So he has requested your lordship to kindly fix the matter as the last item or in the next week, your lordship.
Last item in the next week.
No, last item today, your lordship, or next week, or as per your convenience. Your lordship. And I really seek apology for that.
What is this matter about?
My lord, it's about a delimitation of a exclusion of a village from this Rabah Hassan area, my lord. My lord, one thing, my lord, I will just bring it to your notice, my lord. Just I have been informed that my friend has called me that there is a matter where WPTBC was a party, my lord. So now I see, my lord, that WPT is party. Now problem is that if I have to appear, my lord, that department does not exist anymore, my lord, from 2022. That has been, my lord is aware of. That has been.
But you are a standing council?
No, my lord, I am standing council for tribal affairs. I was, my lord. Now that department.
You have been removed from there.
Not removed, my lord. That department has been dissolved, my lord. Bifurcated, my lord. So
now do you hold any brief for any of these?
My lord, if now just what I would like to, my lord, commit is that now this will come under tribal affairs plains department, my lord, and they have to be made a party at least. Means
you are?
I am the standing council for that. And now, since that department is gone, my lord, WPTBC bifurcation.
Trifurcation.
Trifurcation, man.
One is borough.
Borderland welfare.
One is?
One is social justice empowerment.
And the other is plain.
Tribal affairs. So this will come within tribal affairs.
You represent them.
I can represent them, man.
So why do you need to make them a party?
My lord, they are not a party in this case.
The parent is there. The father is there. Why do you need the son? Why do you need the son? The father continues to be represented by the legal guardian, you. Then any additional input will come when you file. Are you telling me that you are going to file an affidavit?
My lord, I will seek instructions, my lord, from the tribal affairs whether they can give any input. Because in between, my lord, there was another delimitation last year. So if any effect has come into this, that is actually what I want to find out.
But you continue to represent.
Yes.
I'll record.
My
Mr. Ardhor, the learned counsel appearing, learned counsel who is the standing counsel of the what?
WPT and BC.
No.
Tribal Affairs Plains Department.
Tribal Affairs and Plains Department of the Government of Assam, which is one of the departments formed out of the trifurcation of the welfare of plains, tribes and backward classes department of the government of erstwhile welfare of plains, tribes and backward classes department of the government of Assam submits that he would like to take instructions as to whether the present delimitation proceedings, the recently concluded delimitation proceeding, had any impact on the present proceeding. Taking into account the above, this the matter again on 22/2024. Full stop. The name of Mr. Ardhor is shown as the counsel representing the Plain Tribes Department of the Government of Assam.
Number 3.
your lordship method, permit method, which method taken up after method.
You are asking for who should appear? Who will be appearing?
So Hidul Islam, Maliki Islam. If
First of all, Sohidul Islam's name is nowhere there. Mr. T. Islam is there,
yes,
or
sir.
his name. But you have all along been appearing. Yes, Mr. Z. Hussain. I am not Z. Hussain.
My lord,
Learned counsel for the petitioner is present, 35/2022. Then, what is the case? Yes, he is not prepared. Tell me what is his case.
My lord, case is, my lord, that in the year 1991, there was an
Of?
auction of a particular plot of land. Because of, my lord, failure of depositing revenue. I participated in that particular auction. I was I was the highest bidder, so I was accorded with the particular sale. And my lord, 1992, it was confirmed. That is, I am speaking from the record. My
Auction sale of a
auction
patta.
sale. Auction sale.
Sale of a patta.
Patta. There was a bidding, my lord. I stood highest bidder.
Then they challenged the
In
auction sale.
1992, my lord, bid was confirmed. 1994, they challenged it, my lord. It was rejected.
Before Board of Revenue.
No, my lord, before the ADC.
Then?
Then in 2007, they have come to the, before the Revenue Board saying that there was a condonation petition also, my lord, that we were not aware of the particular sale.
Then,
my lord, condonation was allowed, my lord, and petition was allowed in the Revenue Board. We have come before this honorable court by way of a writ petition.
This one?
No, earlier. Oh. So that order is there. In 2013, this honorable court remanded back the matter to the Revenue Board. Then the Revenue Board said that no, condonation is not proper. So it is not, if matter is not condoned, so matter ends there. Now they are coming in paper.
there might be contractor allowed by the market.
By the?
By the Revenue Board, and I.
But why did you come after 2 months, so long?
17.
Didn't you file an application before the ADC?
That is from the record.
And when it is your application filed, the order being passed, you have to be responsible. And why did you approach after so many years?
So auction sale in my absence without certificate. Auction sale, my lord, without certificate, the record, my lord, and my lord, auction is done without my knowledge. And therefore, immediately filed an exhibition due to the, my lord, continue either.
But why should we open certain things which is already closed?
Yeah, immediately filed the Revenue Board. Revenue filed already along with the contradiction, they filed both the petition, and my lord, it my lord, Revenue Board passed the order along with the contradiction.
No, the condonation application was dismissed.
Yes.
In
the year 2014.
Allowed the Revenue Board subsequently challenging my learned parents.
That's okay, but after the matter went out there, the Revenue Court said that we are dismissing. So this court is only going to look into it as to whether there is any error. That's all.
My prayer matters, the court allowed. Then my lord put it the main case, my lord had again, my lord. My lord, otherwise.
And how much? At what price it was sold? What price was it was sold?
Some 800.
801.
Huh?
801.
Way back in 1991, man.
800. How much land?
17 bigger. That, my lord, barren land, my lord.
Where?
It is in the, my lord, BTAD.
Water, underground land.
Water logging. It was under the river for many years. Now it has again come up.
My lord, I have continued with the land revenue, my lord. Recorded. But, my lord,
Did you pay the land revenue during this period, and did they accept the land?
my lord, this auction was, my lord, done without knowledge, without certificate. Record says, my lord, no certificate not there. Expertise order, my lord, this, my lord, I am not aware about the I have not received any.
My lord, what has happened now, my lord? Because I have developed the land, we have developed the land, my lord. So now it has been noticeable, my lord. That is why, my lord, they are coming after. Because there is a Tosbilder report also, my lord. The things were as we have approached, my lord, before the authorities by the legal means, my lord. All I have paid the money and
Understood. You have done it properly. But whether he has done it properly,
well, there are reports have been from with their own petition, my lord. Their report was there. It was fixed, my lord. My lord,
let's see the Board of Revenue's order. This order,
my lord, lordship may look at that order dated, my lord, 2006, 12, 2014.
page
Page,
My lord, 85,
2014 order.
85 page.
this appeal is against the option sale of the disputed Swanson appeal. Appeal for the law to continue. Appeal has been filed in the year 2007. There has been a delay of 15 years. I filed an application for condonation of during the claim filed an application which was by in Now, what is your stand taken in your memo of appeal? At paragraph number 20, page 8.
May I read it? Yeah, 2022.
Your statement is wrong. Page 82 made a false statement. If you have filed that application, is it your stand that you did never file that application before the authority? Page memo of appeal. These type of matters can not remain any further. Application under section 51.
Okay.
Matter after.
Huh?
The matter after with my.
Yes, with cost. The order repeat the thing.
The page 41.
Mr. Counsel, I think the best option is to file a suit.
Page 41. is code one.
Oh.
Of my lord,
Para 20.
no, my lord, the annexure 5 is code.
What is that?
Yes, my lord, as per your order, arriving at the village mentioned in the notice, when I asked the villager about the position of the replied that he did not reside in that place. I obtained their signature.
No. Repeat. 41. What is this? As per your order, arriving at the village mentioned in the notice, when I asked the villager about the Sienta, they replied that he did not reside in. Then, no, that is immaterial. I'm not on that. I'm only on the question. Now, here is a case that unless you get that declaration that you did not file that application, in your memo of appeal, where's your memo of appeal?
My lord, para 20. Yeah,
Where's your memo of appeal?
memo appeal.
What is this page 111? Who is Abbus Salam Mullah?
Hello, my lord, is the attorney holder.
Oh, these are all through attorneys.
Para 20 in the appeal memo, my lord, they have said we have engaged our attorney to find out if any application was filed, but we could not find one. So, my lord, there then is not denial, my lord. They say, as para 20 what they have said, my lord, the attorney of the petitioner submitted the application for copy of the application for annulment of sale, but the same was not furnished to the petitioner. After going to the record, the attorney of
The petitioner submitted the application for a copy of the application for annulment of same, but the same was not furnished. After going to
record, the attorney of the petitioner did not
not
find
find any application alleged to have been filed for annulment. He stated, mentioned here is that if an application alleged to have been filed after a month by the it does not reveal that no date was given for the also,
Now, my lord, order lordship will find in the appeal memo at page 65. Page 65.
65.
65. 65. From their appeal memo.
Yes.
Order of rejection by the APK.
Yes, what is it?
This is the order, my lord, which says that, my lord, যেহেতু তহসিলদাৰৰ ইংৰাজী তাৰিখৰ উপায়ুক্ত মহোদয় ধুবুৰী ইমান ইংৰাজী তাৰিখে
No, but why didn't the Board of Revenue call for the records? Because there is a specific allegations being made that we don't know how this order has been passed. And this order does not have any signature.
my lord, signature is there in the site.
Now, why the Board of Revenue, when there was specific averments made in paragraph number 20, say, look here, we never filed this application. Then why the Board of Revenue did not look into that aspect?
My lord, because at that point of time, as I remember, I was the counsel, my lord. I remember way back, my lord, 27. They didn't file a separate condonation petition, my lord. As I remember.
No,
no, later on they filed. After the High Court, they filed.
Anyway.
Yes. But
that was rejected.
Yes.
On the ground that they knew it. Now, their
Yes.
basic contention is they did not know it because that application, yes, paragraph 20, I have duly mentioned to the effect that it is there, but he never filed any application for enforcement before ADC. That is their specific statement in paragraph.
My lord, they are not taking that stand. They
Yes,
say,
kindly see.
they say that it may be,
Mr.
but
Hazarika, kindly see paragraph number 20. I'm coming in 5 minutes. Paragraph number 20 of the memo of appeal.
28, I have mentioned my.
20
Yes, yes.
of the memo of appeal. Read it properly. I'm coming.
Purportedly filed by the petitioner for annulment of sale, but the aforesaid application was rejected by holding that there is no scope for annulment for sale after the land was sold in auction on 14/11/1991, and confirmation of the same was done on 4/4/1992. The attorney of the petitioner submitted the application for copy of the application for annulment of sale, but the same was not furnished to the petitioner. That case is not that we have. Yes. After going to the record, the attorney of the petitioners did not find any application alleged to have been filed by annulment of sale. Be it pertinent to mention herein that it is an application alleged to have been filed after 23/3/1994 by the petitioners, but the order sheet does not reveal that the order was recorded in the order sheet of LS case number 101/1991, but no date was mentioned in the order sheet. So the application for annulment of the sale was rejected. It is also evident from the order sheet that it was recorded that the application for annulment of the sale was rejected, but there is no signature of the officer concerned who has rejected the application. The fact stated herein about clearly indicates that the entire exercise of auction sale and confirmation of the sale was done without following the due procedure of law, and the same was passed in connivance of the revenue officials, tahsildar, and the private respondent. The entire exercise of the auction sale and confirmation of the sale was carried out at the behest of the private respondent as well as the revenue officer.
Now, if you see the order which has been passed,
yes, 65, my lord. There is a signature.
56. And 63 is the my lord is Mandapula.
65.
kindly see from the impugned order.
Yes.
Claim of the appellant is rebutted by the respondent number 6. It stated that the appellant had filed an application before the Deputy Commissioner to brief for annulment of the sale, which was rejected by the agency by an order dated 12. In support of this, the learned counsel for the respondent has shown the copy of the state order, the copy of the order sheet, the state as presented by the appellant with the memo of appeal. He also pointed out that the appellant had mentioned this in paragraph 20 of the memo of appeal. It is seen from paragraph 20 that the appellant had admitted this order having been passed, but has claimed that no application filed by him was found in the records by the attorney who took for it. From the above, it is evident that the matter was stated by the appellant before so and so, whereas it is not the case. If you see paragraph 20, he never admits that he has filed it. He never admits. He asked the attorney to go and look out there and find out as to whether there was any application there. In fact, there was no application out there. That is his specific submission in paragraph 20. So isn't this a wrong appreciation of facts?
My lord, I will submit, my lord. 1994, there is an order. There is no diligence, my lord. 2007, there are some.
Therefore, he says
yes,
that I don't know anything from there till 2007. That is his case.
Yes,
specific case.
Yes, then 2007.
Now, under such circumstances, it the Board of Revenue has only applied the fact. You see, what is the appreciation? It says that as there is an order being passed, so it is he has filed it. That is not what has been mentioned in paragraph 20.
My lord, then I would say order is there on record, my lord.
So under such circumstances,
it says that
now under such circumstances, what the authority should have done? The authority should have called for the record of that.
But my lord, condonation petition was disposed of first.
Oh, while disposing of the condonation application, if that is the issue, isn't it the requirement of the authority concerned to call for the records of allegate number so and so?
Probably, my lord, as these were annexed, so they didn't call for.
No, that application is not there.
But order is there, my lord.
Order is there, but order whether he has filed or not, that is the question which should have been looked into by the Board of Revenue.
My lord, they are also not sure. They say that we have put the attorney to find out.
No,
They,
they
that is
don't
not-
say, no.
They have said, my lord, we have not.
No. Kindly see paragraph 20 clearly.
He said, my lord.
He uses the word, it appears from the order sheet that an application purportedly means allegedly, filed by the petitioner for annulment of sale, but the aforesaid was rejected by holding that there was no scope for annulment and confirmation of so and so. The attorney of the petitioner submitted the application for a copy of an application, but the same was not furnished to the petitioner. After going through the records of the attorney of the petitioner did not find any application alleged to have been filed for annulment of sale. Be it pertinent to mention that if the application alleged to have been filed after so and so by the petitioner, but the order sheet does not reveal that the order was recorded in the order sheet in here, but no date was mentioned in the order sheet in here. It is also evident from the order sheet that it was recorded that the application for a year was rejected, but there was no signature of the officer concerned who had rejected the application. The facts stated clearly show the entire exercise was conducted by so and so in connivance with it. The entire exercise of auction and confirmation was carried out at the behest of the private owner as well as the so and so. So he categorically denies filing of any application.
My lord, what I understand, my lord, he says, my lord, if he is sure that he is not filing, why should he go for an apply for an application? That may be, I humbly submit, my lord, that may be also misplaced. I do not know. That I do not have authority to say anything about the record. But the ADC's order is there, sign is there, signature is there, and date is there. My lord, why a prudent
Under
officer?
such circumstances,
Why a prudent
wasn't
officer?
it necessary for the Board of Revenue to call for the records of this case, LS case number 103 of 1991?
It's probably because certified copy was annexed. So it was not.
Certified copy of only the order.
Yes.
But he has not admitted the filing of the application. He has categorically, you see, paragraph 20 is completely different from what is recorded out there in the impugned order. He duly admits, yes, there is an order being filed.
But my
But
lord,
I don't know.
but my lord, that order is evident, my lord, that an application is filed. Because a prudent officer, why he will pass an order without any application, my lord? That is my reasoning.
Yeah. I have seen many cases with the Board of Revenue, how constantly.
I leave it to your lordship.
No, I think this is a case for remand to the year for deciding afresh.
My lord, that was done in the year.
The condonation application has been decided afresh, taking into account the contents of paragraph 20 in its entirety. Taking into account that in paragraph 20 there is no admission on the part that they have filed the application. Let them decide. They may call for the records of that
My lord,
and look into it.
there was already an order of this honorable court. They are passing and speaking order, everything, my lord, 2013. Yes. This honorable
Speaking
court.
order is there, but
Yes.
the speaking order, once a speaking order is being passed, the speaking order has to also resonate on the basis of the materials. The materials does not show that he has admitted filing of the application.
My lord, I'll just bring your lordship's attention to that order of this honorable court.
I've looked into it.
Yes.
That is B.K. Sharma's order.
Yes, yes. My lord, thoroughly it was, everything was discussed, my lord.
Not necessary.
Everything was discussed, my lord.
Hello, we'll have it some other day. What do you think? Huh? He wants an adjournment.
After one.
Huh?
After one.
No, I'm not here.
Yeah,
Let us
other
have it
than
some
qualified,
other day.
contractor may be allowed.
Huh? What?
Contractor may be allowed and
Why should you ask for adjournment? Let him argue before some other court. They will give you a better.
my prayer that is
I have full faith
No,
in
you
your lordship, my
have
lord.
not prepared. You
But
only said in the
that is
morning
my
you
prayer,
were
my
not
lord.
prepared.
Contractor may be allowed and creditor may be permitted.
Why should I allow the condonation application? It is not more for me to allow the condonation. It is for them to allow. But the fact that this order has been wrongly passed is the question. Thereafter, the Board of Revenue may very well decide
My lord.
on the basis of the application. But why should I?
My lord.
You are asking for time.
Yes.
That's allowed.
At the request of the learned counsel for the petitioner, the matter stand adjourned to be lifted up to it.
Public.
Otherwise, I would have allowed.
Item 4.
The order of the Board of Revenue, my lord, holding the order of the ADC, which my application was dismissed summarily, my lord, the ground of limitation.
Hmm?
So in this case, my lord, the Board of Revenue summarily dismissed, my lord, the appeal on the ground of limitation without notice. If you notice the page 47.
No. Board of Revenue's order is where?
Yeah, my lord, page 47, annexure 8.
So what is wrong with the order?
Well, what has happened in this case, my lord, in fact, the case of this petitioner previously also come up with another in another issue. But the facts are like this. There were 8 brothers and sisters. These petitioners are 8 brothers and sisters, 3 brothers, 5 sisters. Their father passed away in the year 1989. They were all minors. And mother also, after 2 years, she also passed. During their minority and taking advantage of the minority, several people of the same village, they encroached to possession of their land. And when they came to know that certain land were owned by their father, and there was a case which came to a lot that there was one person who purchased from another who claimed to have purchased the land by an affidavit. And by using these fraudulent methods, these people mutated their names in the Jamaband and became the possessors and owners of the land. Therefore,
Interfaith?
Yes, I have the copy. In that case, interestingly, the deputy commissioner also took a different view of the matter, allowed on the ground of limitation, and the learned Board of Revenue, albeit different member, also admitted my appeal. Here, in fact, their appeal was dismissed, and then I take him subsequently to your lordship upheld the view of the learned Board of Revenue. Now, the question ultimately is that how a person mutates his name in the record of revenue. Here is the case, if your lordship sees. My father, as I said, we are 8 brothers and sisters. A lady comes in the year 1992, applies principally to the circle of claiming to be a Dharmokanya, which is an adopted daughter. So, as the lordship knows, under the Muslim law, there is no such concept of adoption or Dharmokanya at all. I have given the name of a real father. They have responded by filing an affidavit. It has not even been denied that that lady is actually my sister or has some relation with my. In fact, in the written statement that was filed by exponent number 3, that particular lady before the court of the learned ADC, she claimed to be the Dharmokanya and described herself in the affidavit also as a Dharmokanya. The fraud started in the year 1992. She mutated her name in the year 1995. Subsequently, the respondent numbers 4, 5, and 6, all of them are her own family. So she got her name mutated, subsequently she transferred 4, 5 and 6. That is how, this is the story. So the learned ADC as well as the learned Board of Revenue lost sight of the fact that I had filed the appeal and the petition under 147 as well as 151. Under 151, there is no question of time. There is no question of limitation. The fetters that are there in regulation 147 or in 148 for that, they are not there in 151. So this is the case,
151 power is reserved for whom?
No, any case in which the board or even the deputy commissioner feels, thinks, or is of the opinion that it is the case where the record should be called for. Yesterday or appropriate of the past.
Isn't it a discretion of the court?
Discretion, yes.
So,
Discretion is there. But the fact remains that, my lord, if they were not satisfied, first of all, my lord, my specific case was not dealt with properly. I explained that we came to know in 2013. Then we made inquiries immediately in 2014. Within 1 year, my lord, we filed the revenue. Revenue appeal was dismissed, saying that basically, my lord, it was not, nothing was dismissed. Immediately thereafter, we came in 2014 for the Board of Revenue. Board of Revenue says that your explanation is too vague to be accepted. The fact remains that there is the right of the respondent number 3 to come into possession of that land, get that name mutated. Was not seen by any of the authorities.
But isn't it the case for civil suit?
No, civil suit also we have filed.
So
we have filed last year. That is also pending.
I think your civil suit will decide everything.
Well, now interestingly, in the civil suit also, they have filed, the other side has filed a petition saying that matter is pending in High Court.
So I'll dispose it of saying that the civil suit will take over everything. I think that is the way out. Because here, touching out here will be the difficult. So the only way out is because whatever may be, if you are on the right over the land, you must have filed a suit for right title and interest
declaration of right title
along with for recovery of possession. So this mutation is only for the purpose of the revenue.
Yep.
So under such a time, mutation given or not doesn't make any sense. It's no conferment of right. So under that, the civil will take it forward. I think that is the best part of it.
If your lordship indicates that all questions remain open for the civil side, because otherwise there might be an issue.
I would not touch this order, but that will be all the proceedings shall be subject to the outcome of the civil court. I think that is the best of it. What's the number of the civil court?
PS 33 of 2020. 33 of 2020. PS
recently filed.
Recently.
Because the matter is going to come before this court.
No,
why?
They filed in the year 2023.
Then why? You came to know in 2013 and you are filing it in 2023.
Cannot disclose the reason. They were under advice of. It was not me who advised.
No, I am not on that. I am not on Mr. Ganguly or anything. I am on the question is, see the bona fides of the person concerned. You shouldn't have filed. I don't understand that is. If there is any problem as regards which touches on the title, I think the mutation doesn't help you anything.
The collateral thing, the main
it's only a collateral thing. The learned counsel appearing on behalf of the petitioner.
One.
Yes.
The orders of the agency and Board of Revenue not prejudice me in that.
I would not say that. I will say that the orders passed here will be subject to the outcome of the civil suit. The civil suit will take it. The instant petition has been filed challenging the order dated 17/11/2014 passed by the Learned Assam Board of Revenue under section revenue in case number 79 RA bracket L oblique 2014, whereby the appeal of the petitioner was dismissed on the ground that the learned ADC was justified in dismissing the appeal filed by the petitioner on the ground of limitation. It has been this court, having heard the learned counsel for the this court had duly heard the learned counsel for the petitioner, as well as Mr. Yuda, the learned counsel, additional senior government advocate. It has been duly submitted that the petitioner have also initiated a civil litigation for declaration of right, title, and interest over the land, which is the subject matter of the present proceedings, as well as for filed a suit for right, title, and interests, as well as for declaration of right, title, and interest, as well as for recovery of possession of the land, which is the subject matter of the present proceedings. The said suit is registered and numbered as title suit number
33 of 323.
and pending before
The Honorable Civil Judge, Senior Division,
the Court of the Civil Judge, Senior Division, so and
Lakhimpur at North.
so. This court have duly given an anxious consideration to the matter. And it being a well-settled principle of law that mutation does not confer any title, but is only and does not confer any title, comma. And the rights in respect to the land has to be adjudicated by a competent civil court. Under such circumstances, while this court is not interfering with the order dated 17/11/2014 for the reasons so assigned, this court, however, observes that the mutation so granted to the respondents shall be subject to the outcome of the civil proceedings. With the above, the instant petition stands expressed.
Public.
Item 5.
Yes, NNB Chaudhary, Veji. Yes, you are appearing. Tell me, what is your case?
My lord, the petitioner, all petitioner are the street vendor, and they are vending in the North Lakhimpur town. And the municipal
Not
board
to evict the petitioners from their place of business of North Lakhimpur town area, including entities and daily via so and so, and be allowed to continue with the vending in their respect without any hindrance and or to finalize the process of creating vending zone. Then?
Yes, my lord, as per my lord, the
Yes, who is appearing for the municipality?
municipality did not file any appeal.
Nobody is appearing. There is a vending zone.
My lord, they have formed the town vending committee, my lord, in the year 2014, my lord. Thereafter, that was, my lord, totally absolute, my lord. Nothing has been done by that town vending committee. And the earlier chairman, my lord, of 2014 is remained there, my lord, which is at page 123.
Then?
They have doing nothing, my lord, as per the law, my lord, of the Street Vendor Protection of Livelihood and Regulation of Street Vending Act 2014. That, my lord, Act Annex, my lord. That is, my lord, 103, my.
Now, who is the respondent number 5?
The respondent number 5 is the, my lord, FP, my lord.
What does he say?
He said that they have due to some
creating nuisance and causing obstruction to the pedestrians and vehicular traffic by vending on the side of the. You're vending on the side of the street.
vending is
Yes,
done
ma'am.
on the all altogether, my lord, the street, my lord, in the side of the street.
No, don't treat it. It is very difficult.
My lord, as per the, my lord, that act, my lord.
And as per the act also, you cannot bend on the
Yes, my lord,
street.
not in the street, my lord. They have not, my lord, earmarked any pending zone.
Oh, outside. Nowadays you have this new bypass, no?
Lordship.
The Lakhimpur bypass.
Yes.
Give it somewhere nearby.
Nothing has been given, my lord.
No, give it there. One day, some people may go that side one day. Oh, give it them.
Without
They will
obstruction.
die,
they
my
can-
lord, in misdirection.
Huh?
They will
No,
die,
no, no.
my
You
lord.
can't cause this problem.
My lord, your lordship may kindly, my lord, in the, my lord, the judgment of the, my lord, Maharashtra Ekta, my lord, yes, Hawker decision, my lord, there is a direction, my lord.
Hmm.
Maharashtra
Yeah,
2015
those
one
are for the
my lord,
Supreme Court to consider.
that, my lord, they have not. my
You
lord,
cannot keep on vending on these things. Sorry. Not on vending on the footpath. Footpath you have to vacate. Your basic thing is that you are thought to be evicted on the ground that you are vending out there in the footpath. Footpath you have to clear. They will clear it. And I will give a direction to the North Lakhimpur thing to consider you for in terms with that street vendors act. That's all. Nothing more than
But till then, my lord, they have
what
given
till
any
then.
place, my lord.
You
till then,
cannot disturb footpaths. The Supreme Court has also made it very clear.
Lord.
The footpath encroachment is not permitted
my lord, they are not in footpath.
They're
They are
on the street,
street.
not in the,
not on the
not in the,
street. No street business.
My lord.
if your lordship, my
No, no, no.
everything enumerated by lord.
Each
from the-
judgment is for the division bench to consider. I've already dealt with this street vendor thing. Nothing doing. You cannot be there. However, there will be a direction to the
Don't
authorities to
consider, my
consider.
lord.
Yes. Therefore, the instant petition has been filed by the petitioners challenging. Yeah, have you paid the court fee? No court fee paid. You choose one of them. Challenging the action of the respondent authority in trying to evict the petitioners from their place of business of at North Lakhimpur town area, including the NT Road, taxi stand to the Delhi Bazaar Road via Courtiniali, Delhi Bazaar Road, CD Road, and to allow the petitioner to continue with the vending in their respective areas without any hindrance and or to finalize the process of creating vending zones and registration of vendors as per the directions passed by the Supreme Court. The claim of the petitioner herein is that the petitioner are vending, are carrying on the business of street vending at various locations in the within the North Lakhimpur Municipal Corporation. It has been also submitted that some of such vendors, some of the petitioners have been issued licenses. License?
Yes.
Given?
Yes.
Where's the license?
that, my lord, that is 70.
Huh?
The applicant have stated that they are not registered.
Now, are you saying, kindly come to page 74. Is this person a petitioner? Amanul Hussain? This is the allotment of market. How does this have anything to do? Huh? The petitioners claim that the North Lakhimpur Municipal Board had issued some allotment letters and have also issued tax receipts to them, which have been collectively enclosed as Annexure 1 series. This court, however, upon a perusal of the tax receipts, finds it relevant to observe that the said tax receipt bears nobody's name. As regards the licenses in question referred to therein, it reveals that certain persons, these are not petitioners.
I have
No.
found their name.
They are not petitioners. Certain persons were allotted licenses by the North Lakhimpur Municipal Board, annual license. On payment of certain fees. However, these persons are not petitioners before this court.
Yes.
The claim of the petitioners herein is that as they are street vendors, they should be provided opportunities. They should not be disturbed till vending zones are notified and the petitioners are duly accommodated. In that regard, the Learned Council has referred to the street vendors, where is that act?
Yes, my lord.
Street vendors, bracket, protection of livelihood and regulation of street vending, bracket close, Act 2014. It is.
My lord, I have annexed for page 10.
One. Full stop. As there was an apprehension on the part of the petitioners that they would be evicted by the concerned respondent authorities, they have approached this court by filing the instant petition seeking the various reliefs as already above mentioned. This court, by an order dated (13/3/2015), issued notice and, as an interim, directed that the petitioner shall not be evicted. The said interim order has been continuing since then. The record reveals that none of the respondents except the respondent number 5 have filed an affidavit in opposition. In the said affidavit in opposition, it has been mentioned that the
Petitioners are not the registered party.
that the petitioners stated, it was mentioned, that the street vendors are creating nuisance and causing obstructions to the pedestrians and vehicular movement by vending in the side of the street and have been evicted as per the existing law. It was mentioned that the petitioners have been creating nuisance and causing obstruction to the pedestrians and the vehicular movement by vending in the street, and therefore they were evicted. You were evicted.
My lord, we are still, my lord, continuing.
They were evicted
I-
as
I-
per
my
the
lord-
existing law.
I have also filed a in reply.
Further to that, it was also stated that in order to ensure public safety and clear passage for pedestrians and vehicular movements, which is the mandate of the relevant law, such as the motor vehicles, the wayside was cleared by evicting the petitioners. Therefore, from the stand taken by the respondent number 5, it is clear that the petitioners have already been evicted. Be that as it may, an affidavit in reply has been filed by one of the petitioners, wherein it has been mentioned that the petitioners have never created nuisance and caused obstruction to the pedestrians and vehicular movement by vending in the side of the street. It was mentioned that the petitioners have been vending, obeyed rules and regulations of the road. It was also stated that as per the decision of the apex court, it is the duty of the competent authority, that is the municipal board, North Lakhimpur Municipal Board, to register each and every street vendor. But no steps have been taken in that regard. It was also, however, mentioned that recently some of the members were accommodated in the vending zone by the respondent authorities, but others have been left out. It is, however, very pertinent to mention that there is no denial to the fact that the petitioners have been already evicted. This court have duly heard the learned counsels appearing on behalf of the petitioner, as well as Mrs. Udas, the learned additional senior government advocate. The learned counsel appearing on behalf, none has appeared on behalf of the North Lakhimpur Municipal Board. This court have, at the outset, it is very pertinent to mention that the act of the street vendors bracket protection of livelihood and regulation of street vending bracket close Act 2014 hereinafter referred to as the Act of 2014 is an act to protect the rights of urban street vendors and to regulate street vending activities and for matters connected therewith. Chapter 2 of the said Act of 2014 relates to regulation of street vending and a perusal thereof, perusal of the provisions thereof would show as to how the town vending committee is required to take steps for the purpose of issuance of the certificate of vending. Chapter 3 stipulates the rights and obligations of the street vendors. From a conjoint reading of chapter 2 and chapter 3, it reveals that the vending that street vending would be permissible only in the vending zones. Chapter 4 relates to relocation and eviction of the street vendors. Section 18, which is in chapter 4, stipulates as regards the relocation or eviction of street vendors. The said section being relevant is quoted herein above, herein below. From a perusal of subsection 1 of section 18, it is clear that the local authority may, on the recommendation of the town vending committee, declare a zone or a part of it to be a no vending zone for any public purpose and relocate the street vendors vending in that area in such manner as may be specified in the scheme. It is also pertinent to mention that as per section 12(2), there can be no vending in a no vending zone. The conjoint reading of section 12(2) with section 18(1) therefore makes it clear that it is the duty on the part of the local authority, on the recommendation of the town vending committee, to declare an area, declare a zone or a part of it to be a no vending zone. And it is under such circumstances only the street vending can be prohibited by the concerned authority. The North Lakhimpur Municipal Board is not represented before this court in spite of receipt of the notice. And under such circumstances, it is not known as to whether the North Lakhimpur Municipal Board, or for that matter, the respondent number 6, have declared any zone as a no vending zone. It is the opinion of this court that without a declaration of any area as a no vending zone, the rights of the street vendor cannot be affected. In the backdrop of the above, if this court takes note of the facts of the instant case, it is accepted, it is apparent that the petitioner herein, apparent from the statements made in the affidavit filed by the respondent number 5 that the petitioners have already been evicted, which have, however, not been denied. It is also apparent from a perusal of the affidavit in reply that the respondent number 6 have also allotted certain vending zones, wherein some have been accommodated, others not. Taking into account the above, that some of the petitioners have already been evicted and some others have already been allocated spaces in the vending zones, this court is not inclined to issue any writ against the respondent authorities not to evict the petitioners as has been sought for. However, taking into account the provisions of the Act of 2014, this court issues a writ in the mandamus, in the nature of mandamus, upon the North Lakhimpur Municipal Board as well as the Town Vending Committee to take appropriate steps in terms with the Act of 2014 for creation of vending zones as well as also vending pustak. And thereupon, if permissible, and thereupon, in terms with the provisions of the Act of 2014, accommodate the street vendors in question.
Harping, my lord, on chapter 2, my lord, section 3, my lord. No street vendor shall be evicted or else the case may be relocated till the survey specified under section 1.
You have already been evicted. What am I going to do with that? You have not denied that. You have not been evicted. This is as far as I can give it to you. If Mr. NNB Chaudhary was appearing, I wouldn't given him that.
Obliged.
In this matter, before my learned friend starts, I'd like to point out one thing. I'm appearing for the respondent number 7. Here, respondent number 7, actually, your lordship, was gunned down on 21/3/2022 and she has expired. And a case was registered under corporate case number 338 of 2020. So the case against the said respondent number 7.
What is he asking for?
They are asking for it's a story with regard to a case where there is an allegation against
the names of respondent number 6 and 8 has been struck off as per the Honorable Court's order. 7 is dead.
7 has been sought
Then what do you want, Mr. Sohan?
My lord, in fact, my lord,
what are you asking for?
the investigation was done, my lord. My lord, attempted an unfair investigation. So I pray by
not be sent for any
for fresh investigation.
Quite a so-called recorded statements recorded of not
there is an allegation that the respondent number 7 have recorded this statement in her handwriting.
Taking appropriate action against the investigating officer. Who is the investigating officer?
That is the respondent number
6. He is 6.
So 6, this has gone. Then what remains in this case? 7 after having died.
That's right, my
You
lord.
want an action against these 6, 7, and 8. 6 and 8 is gone. 7 is dead. What remains?
My lord, other accused are there, my lord, but my lord, I my lord pray before you lordship, my lord, to my lord allow me to withdraw the case, and my lord stay may be vacated so that my lord case may proceed against othering.
There was a stay.
There's a stay order.
Order dated 9/4.
There's a 15 man.
The learned counsel, Mr. S. Chauhan, heard Mr. Y.S. Manan, the learned counsel, had submitted that his client, the respondent number 7, had already expired on
21/3/2022.
21/3/2022. And in that regard, what did you say?
I said that the case against the respondent number
No.
stands abated.
Now, how is it possible? Means on what information
She was shot dead. There's a case registered.
has
She's
it
shot dead.
expired on 20? Taking into account the above and the reliefs which have been sought for in the instant proceeding, the learned counsel appearing on behalf of the petitioner submits that he would not like to press the instant petition. Taking into account the above, the writ petition stands dismissed. On withdrawal, the interim order so passed on 9/4/2015, by which the sessions case number 205/2013, pending in the court of the learned session judge Borpeta was stayed, is hereby vacated. The registry shall intimate the instead order to the court below.
Much of.
For 12.
Time. Yes, where is Mr. Borputari? Yes.
But, one aspect probably I'd like to highlight is the should may kind take up the writ petition. 87B. But before I take your lordship to 87B, page 78 for a moment.
Yes.
Now, this was the application that was filed by the solicitor exercising his choice of retention. It says the prayer of the aforementioned objection petitioner is that the objection petitioner have lands measuring 394 bighas in NK Patta number 3 under Bon Moza of Moza Kilasinduri Gupa, 6 bighas of land under Thopatori village of the same Moza, and 180 bighas in NK Patta number 9 of village Nis Sinduri Gupa of Moza Kilasinduri Gupa. It is to be stated that before almost 25 to 30 years ago, 75 bighas from the aforesaid 180 bighas was sold. And as such, at present, the rest of the lands are within the possession of the objection petitioners. The heirs of the said land are so and so, there are 6 of them. All these heirs, as well as the owners of the said land premises, are residing separately and they have separated from each other after solemnization of marriages. Therefore, the objection petitioners are entitled to 6 shares of the land. Therefore, keeping 180 bighas of Nis Sinduri Gopa, that is number 9, and 120 bighas from other pattas standing in the name of the objection petitioners, the excess land may be acquired. So, out of the total 394 bighas, he says that I want
300 bighas to be kept.
300 bighas should be kept, and 180 bighas in the subject patta should be retained, and 120 from the others excess you may acquire. Now, against this, my lord, at page 80,
Therefore, keeping the 180 bighas of the land from
Nistin,
Chandrayuga
that is
village
patta number.
and 120 bighas of the land from other pattas, taking the name of the excess and maybe.
So his clear choice is patta number 9, the whole of patta number 9, 180 bighas.
Right.
Because Sinduri Khopa is patta number 9.
And he also uses the word and 120 because of the
from,
land of other
other-
pattas standing in the name of the name of the section excess that
And
may
maybe
be
it. So,
from 120.
Yes, 120 because it doesn't specify
But you had 290, 394.
390.
So how do you take care of that?
Well, I'll come to that. 395 I had in patta number 3, 180 I had in patta number 9. So I say that patta number 9.
No. I'll see the next line. Therefore, it is paid by keeping the aforesaid 300 because that is 180 plus 120 to the petitioner. The land standing in the other pattas may be acquired in which
the
objection
petitioner
have
have
no. So out of 394, 94 may be
Yes.
not the 120 or 180.
No, 180 and
So they
120.
want 300.
300. Out of that, he says 118 patta number 9 I would retain, and also 120 from other patta I will retain. Rest you may acquire.
So out of 394, 320.
Yes.
Right.
Now, my lord, at page 80, my lord. Page 80, my lord. Total is more. 394 plus 180. I have 574.
Okay. 520. Yes. 394 is patta number 3 and 180 in patta number 9.
Yes.
So 190 you keep it and other 3 you want 120.
120 and rest you may acquire. Now, against this, my lord, the collector passes an order at page 80. 80. The following.
Yes.
80 Malot has the report of the Kamalpur Circle Officer dated so reveals that Pattadar, Hare Krishna Sharma and other 6 distinct separate families and each one has equal share. Moreover, it is also stated in the said report that they have sold 75 bighas, but it is not stated in which year the lands were sold. Secondly, as per copy of the Jamabandi, only 5 persons' names have the mutation in their favor. However, Sri Hare Krishna Sharma stated in his objection petition dated so the names of 6 pattadars from the total land of pattadars measuring 560 bighas, kathas and lechas, keeping 50 bighas for each 5 pattadars, remaining 310 bighas excess lechas, surplus land to be finally acquired in terms of the amended CP. So they negate one fee that no, you're not 6, you're 5 actually, so you're entitled to retain 250. So 250 if it is retained, 300.
How we get 250?
5 into 50.
No. From the total land of the pattadas measuring 560 katta.
Yes.
A bigha. Because keeping 50 for each pattada. 5 pattada. Remaining 300. Okay.
50 into 5 is 250.
We finally acquired income. So this is the order of
76.
Then
now, my lord, we'll come to that particular statement. We don't know whether it's a final statement, draft statement, nothing. That is at 87B.
7B.
Now, 87B, your lordship finds below, my lord. First, they take patta number 3 and 9.
So they had do it according to that 76.
Yes.
As per the 76 order of the collector,
they do.
They keep 250.
What they do now, what they do is they retain 250 in 3 and they acquire whole of 9.
Huh?
They do just the opposite one.
They give you 310.
They give me 310. That's fine, my lord.
To you?
Yeah, they give me. They acquired 310, my lord.
That is what was to be acquired in 76.
In terms of the order. But what they did was they acquire. They show that whole of 9 is acquired, which I had selected for retention, my lord. They say that whole of 9 is acquired and part of 3 is acquired. As your lordship.
And
do just
thereby retaining only 250 of 3.
Yes. Yes.
But not, you wanted
To retain 9.
180.
180.
180 is only there.
Yes. Yes.
But how 158 is there?
158 because my lord,
But
they
you wanted 180.
180.
How? How do you reconcile that?
My lord, I wanted 180.
You wanted 180 in 9.
Yes.
But 9 in this statement shows
Shows
only
150.
158.
And
How?
a whole of 158 is shown to be acquired. Whereas
Where is that 180?
180 is not there.
Well,
Exactly. Now I'm just showing the glitches in the acquisition. Now, patta number 9, I had chosen to retain. I had said I will retain 120 from 3 and 6. You can acquire rest from 3 and 2. Now they do just the opposite. They acquire whole of patta number 9. Leave nothing to be retained.
but they allow you to keep 250.
They allow me to keep 250.
250.
Now
But
now
258
patta
number 9,
patta number
3.
3. Now, my lord, will see the report of the circle officer at page 105. This was pursuant to the
The final statement has been. What is this page 88?
seen and let the compensation proposals be my lord, allowed.
Now, seen the and peruse the case record, whereas the finance has been issued and excess land since transferred to the government, that SDC submit a report on taking over possession.
And correct the land record accordingly. Let compensation for proposal and the allotment
So
details.
this order is passed on 34/2081.
1980.
Okay.
Now, my lord, after
And
we
when is
file
the date of the final statement?
final statement, my lord,
Has to be prior to that.
my lord, that date is not depicted, my lord, because this is an unsigned copy. It is actually in the form of a return.
It is mentioned as the illegible collector.
Yes. Now, my lord, will come to 105 for a moment.
And what is this? Some scoop?
My lord, this is the appeal that we preferred, my lord, under 7-6, which was not entertained, which is why we filed the first bit.
You filed when?
My lord, this we filed in 2009.
Why so late?
My lord, because this was not shown, because ultimately it will transfer. The final statement was not even published. Now, my lord, page 105, my lord, pursuant to the filing of the appeal, a report was called. If I may read this, that's a bit important. First of all, my lord, para 2 onward, para 3, 4, 5, 6, 7, and 9, it is seen that as per order of the collector 19676, out of the total area of land, 560 bigha 2 kotha 8 acres belonging to 5 number pattadars, an area of 250 bighas of land in total was allowed to be retained by the pattadar. No consideration for orchard was made. It is worth mentioning that the individual share of the land belonging to each of the pattadars was not shown in the order of the collector dated 19676. Further, the details, that is name of the village, patta number, dag number, etc. of the land to be acquired as ceiling, as well as the land allowed to be retained by the pattadars, are not clearly mentioned in the order of the collector dated so and so. Same was the case in respect of the final statement issued thereafter by the collector.
So there he admits that it went for final statement.
As per order of the collector, white memo number so and so, the concerned Lat Mandal of Kamalpur Revenue Circle took over possession of 144 bighas of land covered by NK Patta number 3 of village Bonmoza under Sila Sindri Ghopa, and 7 bighas 2 kathas covered by NK Patta number 2 of village Ghopatori. Also 158 bighas 2 kathas 8 lechas covered by NK Patta number 9 of village Sila Sindri Ghopa under Sinduri Ghopa Moda on 17/6/81. The record does not reveal whether copy of taking
possession has been taken.
No, man. Now record shows, man, now he'll again contradict whether copy of taking over possession of land was handed over to the pattadars or not. Now, Malad, the following page. As per report of the circle officer, both North Guwahati Revenue Circle, entire land of NK Patta number 3 of village Bonmoza and NK Patta number 2 of village Ghopatori under Sila Sindri Ghopa Moza are under occupation of recorded tenants. The land of NK Patta number 9, village Sila Sindri Ghopa, are under occupation of both pattadars and tenants.
As per order of the additional deputy commissioner dated 2799 passed in case number so and so, an area of 250 bighas covered by NK Patta number 3 of village Bonmoza under Sila Sindrikopa was settled in the name of president and secretary Diety Hongram committee who are recorded tenants over the land. It is to be noted that neither any land has been either allotted or settled with anybody till date, nor any compensation has been made
But
to the
recorded. An area of so and so covered by so and so was
No.
settled.
settled, my lord. Now
So
250
your
bighas
250 bighas which were shown in 76 in that final statement,
to be the retainable portion is
that has
actually
also been settled.
is actually settled, my lord. Now, my lord, it is to be noted that neither any land has either been allotted, so I have not been paid compensation. So, my lord, first of all, I had chosen Patta number 9. As per this final statement, they show that you can retain Patta number 3. As per
Then
the,
what happened? You filed a writ.
I filed it.
Then what happened?
My lord, writ petition, they said, my lord, they
Having heard the rate is considered
disposal,
appropriate to
for
dilute the
disposal.
dispute of the application after the
Yeah.
Then what happened?
My lord, 110, they passed the order. 110, they passed the order, my lord. And page 114 is the reason for rejection. If your lordship takes up, paragraph 5. They say it is barred by limited. Then, my lord, we file for review, my lord. And at page 118, my lord, additional chief secretary passes an order. Now, page 121 onwards, if I may just read that part of the order, my lord, by the additional chief
Where does he hold that there is no signature? That it has not been finally published?
Page 121.
There is no any record or document available in LA case that Bhatta ever served. Also, there is no record available in LA case that the Bhattadas had come to know the situation of the land acquired except the alleged of handing over of the created permitted at America then the question arises how a person who died on 38 could access to not it.
Then 123, my lord.
Now, this is an order in your favor.
In my favor. my lord.
Then what happened?
Then 125A, my lord, the additional chief secretary, my lord, he passes an order 125A.
Where?
125A.
I said it is.
Yes. Was rejected as it was time bound. Though some irregularities
That's the order. No, but as of now, where is the particular statement that the final statement was not published?
My lord, it is there in 123, my lord. Page 123, my lord.
The collector has issued the
Orders
orders
to, but no
publish
schedule of
the
land was
final
given.
statement, but no schedule of the land to be expired.
Final statement under
Those
shows that pattadas were allowed to retain 2 but no details like dark patta number of the land against names of individual pattadas were given. Neither any justification was given as to why pattadas were not allowed to retain the land they had opted for. Normally, the pattadas are allowed to retain the land as per their option, but in this case, the statement under 7.3 was finalized without taking into consideration the pattada's opinion for retaining land. Also, there are no records entries in the LA case to suggest that the final statement under 7.3 was published in the manner in which
I don't know who published in the manner. What is it?
Well, it should have been was published in the manner. It's a typo properly. Who published in the manner there is.
In the draft statement, which a draft statement is published at the same. Now, what has happened to settlement of 250 acres? Yes, what has happened, Mr. Sorry. Have you settled the land, 250 acres to somebody else?
No, my lord, all those informations are not forthcoming because, my lord, the records are not available. Yes, we have filed an affidavit to that extent. Because I had also personally.
No, you know, I don't understand. There are two blocks of land.
Yes.
One is NK Patta number 3, one is 9. Now, there has been resettlement operation. Now, these have become now various dark patta, whatever. So, from the earlier map and now present map, it can be very well clear from the who is there, where, who is not there, as to whether these patta, how many other pattas have been issued, or whether the patta number 3 remains or not. That is, you don't even require those records of LA case. That can be very well found out. Now, as of now, whether that land has at all been given to anybody.
That information.
Because that document, that communication by the circle officer shows that these 250 vigas you are giving it to some people.
Yes, Rayati Hongram.
Yes, how is it possible?
Page
What is this
103.
Rayati President and Secretary Rayati Hongram Committee, who are the recorded tenant of the land? Now, if this is the 250 vigas of NK Patta, now if we go, that particular document exists, the final statement exists. Now, as per the final statement, these 250 vigas is the retainable land.
Yes.
Then how can you settle that land to somebody else?
Yes.
Now, if we say that there is no final statement, then the acquisition has gone. Nothing has happened. So what is to be done now? And why do you require? Okay, from the order which have been passed by the additional chief secretary, it makes it clear that nothing has been done properly. There's no mention where, which dark, or maybe a patta may be there. There might be one dark out there. That patta, that is a different aspect of the pattern.
Yes.
Now, if you see the final statement out here, which has been shown out here, kindly come to page 87B.
Yes. 87B, that's what, my lord, I wanted to draw my lord's attention. My lord, it appears not to be the final statement. It is the return. Because Lordship will kindly see, my lord, return of land so and so, see section 5, rule 3. Section 5 and rule 3, my lord, pertains to.
No. Then why there is a signature of Sador SDC Muzada Pattada? Then signature eligible collector. In the return, you do not have that.
Oh, no, yes. It has to be to submit, my lord.
Then why is that? Because if you see the form.
Yes. Section 5, my lord, I am reading it for a moment, my lord.
Section 5 is regarding retainable.
Yes, no, my lord, section 5, my lord, of 1956 Act. Submission of
Section 5 or rule 5?
My lord, section 5.
Section
5 of the 56 Act.
Yes.
For a moment, my lord. For my satisfaction, my lord.
See, I have all the time today. Any person who on the paper. No, there will be a form as per the rule.
Yes, that is at page 354 if your lordship has the same.
Form.
$354.
In what form? What is the form of 7.6? 7.6 without prejudice to any action taken under any other provision, state government may honestly within 1 year from the 7.3. The draft statement shall be made final in terms with the final orders passed under the preceding subsection, and collector shall sign it and affix the same.
Yes.
Now, if that be so, that person making any such objection shall ascertain the date on which the objection will be considered, and on the day the collector shall consider the objection in absence of the objector, and pass such orders as they may think necessary, making the statement final. So this passing of the statement is not in a particular form.
Yes.
Whereas form number 1,
Form number
form
one
number
is
1,
the return. Form A.
yes, form number A
Is the return.
is the return, but
Yes.
here form return of to be held by but here only the signature of the person is there.
Yes.
If we see the form.
Yes.
Now there is nothing out there where here finally see statement of compensation payable to the collector, statement of compensation payable under owner. Now signature of the collector authorized here is there, payment of compensation, realization of funds. Now where is this form? There must be some form, or in 7.3 the final statement.
Here, my lord.
The final statement prepared on the shall also be published in the same manner in which the draft statement is to be published under subsection 2.
Yes.
Now, subsection, the draft shall be published in the office of the Deputy Commissioner, the Sub-Deputy, and in a copy thereof shall be served on the person or persons concerned in the manner prescribed. Any objection received within 15 days from the service shall be considered by the collector, and after giving opportunity of hearing. So this has to be published in so and so. So there has to be a draft statement published.
Yes.
And you are to also give it to them.
Yes.
And without thereby, if you have not given it to them, when it is the rules mandate or the section mandate that you are to give it to them, it is your duty to show that you have given it to them.
Now, going by the order passed by the additional chief secretary, which lordship has done.
He has definitely observed this.
Yes, so many irregularities has been
I'm
committed.
coming after. I have a small dictation to complete one judgment, and then I'll take it.
Yes, yes, my lord. Yes.
I thought that I'll dictate the remaining portion in your presence now.
Yeah.
This court have duly heard the learned counsels appearing on behalf of the parties and have also taken note of the various the materials on record. From the submissions, from the contentions made by the learned counsels for the parties, as well as the materials on record, 2 points for determination arises for consideration. Number 1, whether the respondent State Bank of India was justified in auctioning what is the word used by you? Yeah, repeat.
They said public auction.
in auctioning the gold chain of the petitioner and then appropriating the money received to the loan account? If not, number two, if not, what is the relief to which the petitioner herein would be entitled to? In the foregoing paragraphs of the instant judgment, this court have duly taken note of the facts to the effect that the petitioner had taken a loan of an amount of rupees 25,000 and against the said loan a security was pledged by way of a gold necklace with the respondent State Bank of India. Annexure A to the writ petition apparently shows that against the gold loan number 3695203935A, the gold necklace which was pledged was an 18-carat gold necklace weighing 28 grams. The statement of account of the savings bank of the petitioner bearing account number 31480503313 clearly shows that the amount of rupees 25,000 was credited to the petitioner's account on 16/6/2017. The record categorically reveals that the installment to be paid by the petitioner per month was rupees 1,000. Further to that, from the statement of from the bank statement of the petitioner in his savings bank account bearing number 3140503313, it reveals that till 5/4/2020, there were 13 entries. There are 13 entries of deduction of rupees 1,000 from his account. At this stage, if this court further peruses the statement pertaining to the loan account of the petitioner, which have been enclosed as Annexure I to the writ petition, it would show. It clearly corresponds to the entries so made in the statement pertaining to the savings bank account of the petitioner. It is further seen from the statement of the loan account. That as on 5/3/2020, the total amount payable against the loan amount was rupees 20,611. Thereupon, on 28/3/2020, there was a debiting of rupees 1,000 from the bank account of the savings bank account of the petitioner. And further to that, on 5/4/2020, two additional amounts of rupees 1,000 each were deducted from the savings bank account of the petitioner. Be that as it may, on 5/3/2020, a notice was issued asking the petitioner to immediately pay the amount of rupees 20,611. The postal envelope, as well as the postal receipt, which have been enclosed as a part of Annexure B, also shows that the said document was posted on 28/4/2020. And there is also an endorsement of the postal department of dated 2/5/2020. 2/5, na?
Yes. May I just have case number 2, my lord. I matter is brought up. Just I'll come back.
No, you go. He's there, na?
Lord.
Okay. It is, however, interesting to note that as on the date of issuance of the said notice, a posting of the said notice, dated 5/3/2020, on 24/2020, the amount payable to the petitioner by the petitioner was actually 17,611, as is apparent from the loan account statement. Be it as it may, on 28/6/2020, another notice was issued. Be that as it may, a notice dated 28/6/2020 was issued directing the petitioner to pay an amount of rupees 32,031 and close the loan account. The envelope, as well as the postal receipt, which have been enclosed to, which is a part of Annexure C, however, shows that the said communication was posted on 3/7/2020 At this stage, this court also finds it very pertinent to observe that at that relevant point of time, there was a national lockdown on account of the COVID pandemic. Moving forward, this court also finds it pertinent to moving forward. On a final notice was issued on 16th, final notice dated 16/7/2020 was issued to the petitioner, asking the petitioner to pay an amount of rupees 18,556 and thereby to close the account, loan account. This communication dated 16/7/2020, however, is completely contrary to the communication dated 28/6/2020. In view of the fact that in the communication dated 28/6/2020, the petitioner was asked to deposit an amount of rupees 32,031, whereas in the communication dated 16/7/2020, the petitioner was asked to pay an amount of rupees 18,556. This amount, however, tallies with the loan account amount, the statement of the loan account of statement, bank statement of the loan account. It is also very pertinent to mention that the petitioner was asked to pay the said amount of rupees 18,556 within 7 days of the receipt of the said letter, said notice dated 16/7/2020. The postal receipts the envelope as well as the postal receipts, which forms a part of Annexure D, however, shows that this communication notice dated 16/7/2020 was posted on 20/7/2020. And the track consignment of the postal department in respect to the said consignment categorically shows that on 4/8/2020 the item was delivered, meaning thereby the notice was delivered to the petitioner on 4/8/2020. Therefore, as per the notice dated 16/7 to final notice dated 16/7/2020, the petitioner had to pay the said amount within 11/8/2020. It is the specific case of the petitioner that the petitioner approached the respondent number 5 to pay the said amount. However, he was not given, but his requests were turned down, for which the petitioner issued a communication on 10/8/2020 to the respondent number 5 as well as the respondent number 3. Regional Manager Kachar. Respondent number 3. The endorsement to the communication dated 10/8/2018 20 clearly reveals that on 10/8/2020, the respondent number 5, the office of the respondent number 5 duly received the said communication. The question therefore arises as to whether the respondent authorities were justified in doing in auctioning or selling the said necklace, which was kept as a security. Even without the period of 7 days being over, as per the notice dated 16/7/2020. The answer to the same has to be in the negative, taking into account that the period which was given having not elapsed, the respondent authorities could not have sold the said necklace. At this stage, this court also finds it very pertinent to take note of that when the instant writ petition was taken up on an earlier occasion by this court had made a pointed query upon the learned counsel appearing on behalf of the State Bank of India as to under what provision it was so done. Initially, on 9/10/2023, it was informed to this court that it was done under the provisions of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, for short, the Act of 2002. Under such circumstances, this court had inquired with the learned counsel for the respondent, State Bank of India, as to whether such a course of action was permissible, inasmuch as to take an action under Section 13(4), there is a requirement of issuance of a notice under Section 13(2) of the Act of 2002. Under such circumstances, the learned counsel for the State Bank of India sought for time to obtain instructions. Thereupon, when the matter was listed on 17/11/2023, it was categorically stated that the action was not taken under the provisions of the Act of 2002, but the action was taken on the basis of the loan agreement and some master circular. However, he submitted that he would like to place the same by way of an affidavit. Be that as it may, however, under such circumstances, this court had granted some time to the State Bank of India to file the affidavit. But when the matter was taken up, it was duly submitted that there are no records available with the State Bank of India for which the affidavit could not be filed. This court, however, finds it very pertinent now to take note of the submission made by Mr. L. Talukdar, the learned counsel appearing on behalf of the State Bank of India, to the effect that the action was taken by the State Bank of India in terms with Section 176 of the Indian Contract Act 1872. Contract. Section 176. The said submission, in the opinion of this court, is totally misconceived. On a reading of Section 176 of the Indian Contract Act 1872, taking into account that Section 176 would only come into play after giving the pawnor a reasonable notice of the sale. In the instant case, though a notice was issued on 16/7/2020, thereby intimating that the petitioner had to close the loan account by making a payment of rupees 18,566 within 7 days from the date of receipt of the letter. But even prior to the said amount, prior to the period having expired, the respondent authorities have sold the gold necklace of the petitioner in question. Under such circumstances, the application of Section 176 to the present fact of the Indian Contract Act 1872 to the present facts cannot be made. Therefore, it is the opinion of this court that the respondent State Bank of India was not justified in selling the gold necklace of the petitioner. Prior to 11/8/2020, which admittedly was done. This takes the decision in the point for the decision in this point for determination leads this court to take a decision on the second point for determination as to what relief the petitioner would be entitled to. Before deciding the said aspect, this court finds it very pertinent to mention that the respondent State Bank of India is an authority within the meaning of Article 12 of the Constitution. It is well settled that public law proceedings serves a different purpose than the private law proceeding. The relief of monetary compensation as exemplary damages in the proceedings under Article 2 to 6 of the Constitution by the High Court for infringement of the rights guaranteed under the Constitution is a remedy available in public law and is based on the strict liability for contravention of the guaranteed basic and indefeasible rights of the citizens. the purpose of public law is not only to civilize public power, but also to assure the citizens that they live under a legal system which aims to protect their interests and preserve their rights. Therefore, in the proceedings under Article 226 of the Constitution, the court can grant compensation by way of penalizing the wrongdoer and fixing the liability for public wrong on the state, which had failed in its public duty to protect the rights of the citizen. In the perspective of the above, and taking into account the facts involved, it is seen that the respondent authorities, respondent State Bank of India, had illegally and without any proper justification have sold the gold necklace of the petitioner. Under such, it is also seen that an amount of rupees $18,618 was appropriated from the said sale, and thereby the loan account of the petitioner was closed. Under such circumstances, taking into account the illegality so committed, and as the chain has already been sold, this court is of the opinion that the petitioner is entitled to the value of the chain after deducting the amount of rupees 18,618. The value of the chain has to be taken into account on the basis of, as on the date of the price of gold on 29/7/2020, when the said amount, when the amount of 18,618 was appropriated to the account of the petitioner, was appropriated to the loan account of the petitioner. The responding authorities, more particularly the respondent number one, the respondent authorities jointly and collectively are directed herein to pay the petitioner the amount of the value of the chain in question within a period of 3 weeks from today, from the date a certified copy of the instant judgment is served upon the respondent number 5. In paying the said amount, it is clarified that the amount of rupees 18,618 should be deducted. This court is next. This court further is of the opinion This court further is of the opinion that the petitioner is entitled to some compensation though there cannot be a straitjacket formula which would determine the amount of compensation to be paid. But it is well settled that while awarding the compensation, the court would have to take into consideration the loss or the damage that might have been caused to the person who have suffered on account of the mistakes of the who have suffered on account of the violation of his rights by the authorities. This aspect have been already taken care of herein above, wherein this court have directed the respondent authorities to make the payment of the value of the chain minus after deducting the amount of rupees 18,618. The second limb of compensation relates to general damages so that the concerned officials of the State Bank of India follow the applicable law in both letter and spirit and are put to notice that not following the law, applicable law, would result in they being liable to make payment of monetary compensation to the affected citizen. It is the opinion of this court an amount of rupees 50,000 would be a reasonable amount to be directed to be paid by the respondents jointly and severely to the petitioner as a deterrent this court further finds it it is also relevant to take note of that the payment of compensation so granted by this court so imposed upon the respondent State Bank of India. This court, however, grants the liberty to the respondent State Bank of India to take appropriate action against the erring officials and recover the said compensation from the salaries of the erring officials. In view of the above, the instant petition therefore stands disposed of with the following directions. The respondents herein are jointly and severely directed to pay the amount of rupee, pay the value of the gold necklace of 28 grams of 18 karat gold necklace weighing 28 grams taking the value of the gold as on after deducting an amount of rupees 18,618 within 3 weeks from the date as the instant judgment is served upon the respondent number 5. Number 2. The respondents jointly and severely are directed to pay the amount of rupees 50,000 in the form of a compensation to the petitioner within the said period of 3 weeks from the date of submission of the judgment of the submission of the certified copy of the instant judgment to the respondent number 5. Number 3, the State Bank of India would be at liberty to take appropriate steps for recovery of the said amount from the erring officials. Next. With the above, the instant petition stands therefore disposed of. You want one post? Post? No. No, it's okay. I have given the to be paid within 3 weeks, and the value as on that date on which it was appropriated, and then minus 18,000 and 50,000 as compensation.
Deep level.
Yes, Mr. Bachchaji. Who is appearing for the other side? Huh? Okay. There is no standing out. Yes. What are you challenging?
Well, there is a tender for laying cut line in the border of Mizoram and Indo-Bangladesh.
Laying that Pipelines where?
Pipeline.
It is the tender. Yes.
And there were 3 respondents. With that. Out of that, the number 3 is lowest. So our case was that the conditions laid down in the tender have not been fulfilled by the respondent number, by the bidder number 1 and 2. But before that, we finally the presentation that to verify that the respondent authority did not pay it. Thereafter, the second representation. Then also it. Only thing is that there is some guideline given to the bidder to see their credibility.
But why are you applying here? File the petition here. The tender was issued from there, from Mizoram and Arunachal. Where was the tender issued?
It's an online bidding process.
Yeah.
The response are not online. They have an advocate in that as well as in market of it. The supervision of work is done from Guwahati and a private account work contemplated awarded is from Assam. It has also local office in Guwahati, Assam. And Malot, it's a part of cause has occurred in Mizoram.
No, the main part is there.
Cause.
The main part of cause of action is there. Why are you approaching here?
The cause of action partly arises here or
No, how does it arise? Because you are submitting the tender by e-tender, that's all.
yes, that is why.
The
Online.
respondent upon whom the award is contemplated is L1 is also from Guwahati, Assam. We have seen a part. That is the Assam supply syndicate. Respondent number 8.
Has the award been given?
Award has not yet been given. So we are contemplating to have approached.
And where is the Guwahati office is here?
My
And what is the duty of the chief manager? Show me from the tender document that the chief manager has any role out here.
the tender document only has been issued by a person, namely the digital. One person called Sunil Kumar Dhamma. One person, namely Sunil, page number 68, Malo, at page 68.
Now, what is the role of the chief manager?
We have been informed, Malo, that each person is the controlling authority of Guwahati.
No, it must be written somewhere.
No tender doesn't reflect any.
Then how do you bring the jurisdiction here? Because that person's maybe he may have his office out here. But that doesn't mean that his office being here with the tender is there, everything is there. Then why you are approaching here?
Since it was online, partly cause of
And your office is also, you are from?
I'm from Hyderabad.
Then Hyderabad, everything. Why Hyderabad, Mizoram, everywhere it is there.
Concurrent jurisdiction.
Show me that the chief manager has any role to that effect. Then only the petition can be entered.
We have a local office in Guwahati, Malot.
You have a local office doesn't make it. But you are going to, from where did you submit the tender? From Hyderabad. Then and that is why you don't find they must have filed a caveat there. Mr. Buragoy, let the matter come up on Monday. I'm saying why. Some other Monday, I'm not taking up this bench. So you may, this order, for me, it is, I don't see any jurisdiction here. So Monday, that court may grant you that.
That's a different thing. You know,
No, Mr. Vatsaji, otherwise the thing is, the problem arises, everything is in Mizoram or Arunachal Pradesh. You are from Bangalore or some Hyderabad. Only one person is here, but the fact that he being here has no meaning out here unless that person. Let's see what is the allegation against respondent number 8.
Your Lordship may kindly come to Annex 4. At page 81. Where he did.
No, I've seen it. You are saying that these people have not done any electrical work.
No, not only that, that they have not submitted the TTC in order to find out its financial viability.
Therefore, requested that they may please be asked to submit TDS certificate against the execution of electrical works at the project site for the verification at your end.
Because the guideline says that. Page 62.
Yes.
2.3.
Experience of having successfully completed similar work during the last 7 years. Yes. 3 similar work costing not less than 40% of the estimated 2 similar work of 40. That is the work about fixing, testing and commissioning of LED floodlight in Dampa Reserve Forest area. Dampa Reserve Forest area is where? So BP along Indo-Bangladesh border in Mizoram state.
Then below 2, page 63. Clause 2.
Clause 2.
The past experience in similar nature of work should be supported by certificate issued by the client's organization.
Where? Certificate.
Page
Clause?
63.
Page 63, page Roman 2.
Roman.
Past experience in similar nature of work should be supported by certificate issued by the client's organization. In case the work experience is of private sector, the completion certificate can be supported with copies of letter of award and copies of TTS certificate. Will be considered equivalent to the TTS certificate. Then they have not submitted the TDS. And are they only saying about private sector? Where will be?
The value of what is measured from the case.
No. No. If it is only for private sector, then it has to be, because private sector you can manipulate. So therefore they say that you also need the TDS certificate, which will show that the amount has been deducted against this work and duly deposited. That is why it is doing. But government, they have not said. But as regards this, you have to give. Now, have they stated only private sector?
They have not given the TDS certificate is one of our contents. Because we do not know what certificate they have submitted for the authorities, because they are not allowed in the tender.
Has the tender been opened?
The technical bit have been opened by
So tender, if it is open, it will be there in front of you.
no, our document, we can difficulty is their document, we cannot. But so we have given this representation to go and examine if at all they have the quantum and the value of work that has been basically given before the tendering. Because in our last representation at page 86, we have clearly mentioned.
You say that both these persons have not given.
No,
Yes.
Your representation is only that they have not, these other two agencies, see, the other two agencies as mentioned below had participated in here. It is understood from the name that aforesaid are basically trading companies. It is therefore requested that they may please be asked to submit TDS certificates against their execution of electrical work at project site for the verification. You have only asked them.
Madam, at page 86, my lord, my
86 we have explained. It.
at page
Where?
86,
86, second paragraph.
we once again request
And requested you for verification of the thing. So it is your assumption.
no, madam. Because if it hits this particular point, but if they are found they are not eligible to meet cross point zero, then
If
that-
they are found means what?
By TDS certificate if they bring it.
But do you require the TDS certificate if it is a public sector in undertaking?
but they are Surya private company, madam.
So
They are-
you are also a private company.
But I have given my TDS as my work experience because
But you need to give a TDS if it is a prior, if you are doing it with the state,
as per the provisions.
not necessary. So why do you need it? It is your assumption that they are only trading certificate. So unless you show some document to that effect that yes, they are only trading, they don't deal with anything. This is only your. Now let us see what is your pleading out here.
At page paragraph number 10, madam.
Hmm.
Paragraph number 10 at page 20.
Hmm. Let us see how the tender evaluation is being done.
Madam.
6.0 your lordship. Page 64. The following document will constitute a set of
That is the NIT.
Yes.
Where is the instruction to the bidders?
Madam, the audit
You have given some instruction to the bidders
Yes.
here, page 74.
is the relevant portion.
may kindly come to page 75.
Yes.
6.0.
Hmm.
Documents are to be submitted in the office of so before us. And documents submitted shall open as per the time, date, and mention in the NI. Online technical order, your ultimacy 7.6. The tender submitted shall become invalid if the tenderer found ineligible. The tenderer does not upload all the documents as stipulated in the tender document. If any discrepancy is noticed between the documents as uploaded at the time of submission of the tender and hard copies as submitted physically in the office of the tender. So unless the document is seen by the appropriate authority, it cannot be asserted.
In these type of tenders, there is also one provision that you have, these are all electronically done. Huh? Any objections, everything has to be done in the portal.
They have a site plan. They have a plan how to be, my lord, the arrangement has been made.
Hmm.
Then there are also, my lord, PO, my lord,
No. I'm saying that whenever these type of tenders are there, when e-tenders, you are to put it in the everything, any objections are put to in the portal. So whatever it is, as to what is the status out there, will clearly be shown out there. Even this, it has been and the technical, there is no technical objection or anything, will all be available in that. Where are those?
here they have not given us. That is also one of our disputes. We have written this.
No. It will be already there in the portal.
Yes, my lord.
When you are giving a e-tender, everything is there. There cannot be any letter by hand which can be given. All are to be given by in the portal itself. Now, where are those which will show that yes, the moment what happens in a e-tender, the moment something happens, just for example, a award is given or even an objection is being raised, it automatically comes out in that particular portal where if you are there, you are participating, it will come to you and say that yes, this is the thing which has happened now. This is all day to day, everything is being done in a portal. Where is that photo of the portal?
We have, my lord, we haven't been given such things have not yet happened, my lord, here.
No, it has to be, because when the technical bid was open and it was said that everybody was okay, then it has gone to the price bid. There has to be in the portal, it will be mentioned. All these things are duly mentioned.
Only at page 83A, my lord, we were informed, my lord, not even email was received by us, my lord. At 83A, when the price bids were open, my lord would come at page 83.
What is this?
This is how, my lord, the price that were
Booking
quoted.
sheet for the tenderer. This is of yours.
This is mine, my lord.
Then
On the next page is the price quoted by the respondent, number 7.
you have quoted 51. He has quoted 50.
And the
And the
L1
other one has quoted 47.
L1 is
And,
this was open, my lord, on 12th of January, and we were formally intimated without even an email, my lord. We were formally intimated through telephone. That is the irony, my lord.
how did you get this?
This is by going online.
So your only question is that
TDC.
no, whether he has experience of electrical of
And-
that as per two.
And quantum evaluation 80, 40%, 30%, and 80%. Whether he fulfills this percentage of cost. Because what we have been told, he was my supplier. He was supplying this material unofficial sample. Then the tender came out, he was the part. Prior of me, and these are the suppliers who are supplying the materials to me. And I'm basically participating in different things.
So he was in fact your
Yes, that is where we are taking.
subcontractor.
My meeting. But that's the part we can't take advantage of that.
Chief engineer.
May I have it, Mr.
Hmm.
Dear Lordship, protect us. Let it come before your Lordship, whenever it.
No. Very difficult, Mr. Bhattacharya. That is why I'm saying let it be on Monday.
In Miller, meanwhile, they may.
They've already opened.
No.
They would not be able to complete it by Monday. Let it come up on Monday. You see, I would, first of all, for me to, I'm having a difficulty in issuing of a notice in this matter, taking into account the jurisdiction point. Everything is out there in this place. Yeah. So the question of protection does not arise.
But yes,
Hmm.
okay. Only we also had a similar, my lord, query in our mind. But only jurisdiction that I'm trying to draw is on the fact that if L1 is the person upon whom the award is going to be given tomorrow. He is the person who's political.
That is why that is why I am on the question of entertaining, because he is a resident out here on that. That one of the defendants resides out there. So on that basis, one can very well take note of. But the fact is, they have their office here.
Our office.
They have an office out here in Guwahati.
Yes.
But respondent number 8, my lord.
Respondent number
4.
4, they have located office in my lord, in Gate, my lord. That's confirmed, my lord. I have confirmed that. That is chief engineer. And what we were instructed, my lord, is for notice controlled by them. Unfortunately, we do not have any documents to support my statement, my lord. But
page 8, Miller, we have stated that.
and we have also made a statement of my lord.
Okay, we do one thing. Let me issue notice upon respond number 1 to 6 and 8, not 7. 7 not necessary. As regards 1 to 6, you serve it by Dusty. I'll fix it next week on 2nd. I'm not going to pass any stay order on 2nd. Then on that date, I will consider the interim prayer. You take Dusty upon it.
if at all it hits our work order is being passed,
That will be subject to outcome. That I'll make it clear.
That
If any.
Then it's all right.
Yeah. So that anything will be subject to it, and I will consider the interim prayer on the next day.
Yes.
I think that is the best.
Will be
Issue notice making it returnable on 2nd of February 2024. The petitioner is directed to take steps upon the respondent numbers 1 to 6 and 8 by registered post as well as usual during the course of the day. Further to that, this court directs the petitioner to take steps by way of dusty routed through the registry of this court upon the respondent number 4 and respondent number 8 and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner, along with 2 others, had participated in a e-tender dated 10/11/2023 for supply, fixing, testing and commissioning (SITC) of LED floodlight in Dampa Tiger Reserve Forest (DTRF) area from near BP number 2313 to near 2305/2-RI along the Indo-Bangladesh border in Mizoram state. It is the further case of the petitioner that as per the eligibility condition, which is stipulated in clause 2.0 of the notice inviting tender, the work experience mandates that the tenderer must have completed similar works during the last 7 years ending initial stipulated last date of submission of tender. It further stipulates that there has to be 3 similar works, each costing not less than 40% of the estimated cost put to the tender, or 2 similar works, each costing not less than 50% of the estimated cost put to the tender, or 1 similar work costing not less than 80% of the estimated cost put to tender. It is the further case of the petitioner that as per subclause 2, Roman 2 of clause 2.2.0a, the past experience in terms with clause 2.2.0a Roman 1 has to be adjudged on the basis of certificates issued by the client's organizations. However, in the case of work experience pertaining to the private sector, the completion certificate shall be supported with copies of the letter of award and the copies of the corresponding TDS certificates. And the value of the work would be considered equivalent to the amount of the TDS certificates. The record further reveals that the petitioner, along with 2 other tenderers who are the respondent number 7 and 8, duly participated in the said tender process. During the technical objection, during the at the time of this, at the time of evaluating the technical, what is that term used? Technical bid. The petitioner was duly held to be qualified along with the respondent number 7 and 8. The petitioner duly objected to the same, however, the technical committee did not consider. It is the specific case of the petitioner that the respondent number 7 does not have the technical qualification. Be that as it may, the price bid was duly opened, whereby the respondent number 7, the respondent number 8 is the lowest bidder, and the respondent number 7 is the second lowest bidder, followed by the petitioner, who is the third lowest. Full stop. It is the specific case of the petitioner that the respondent number 2, 7 and 8 do not meet the qualification. However, the respondent authorities are taking taking steps for the purpose of settling the said tender in favor of the respondent number 8. This court, for the present, is not issuing any notice upon the respondent number 7, taking into account the primary grievance of the petitioner is against the respondent number 8. The respondents, more particularly the respondent numbers 1 to 6, as well as the respondent number 8, shall apprise this court on the next date as to whether the respondent number 8 duly qualifies in terms with clause 2.0 A Roman 1. Full stop. This court, for the present, is not inclined to pass any interim orders. However, without hearing the respondents to whom the notice has been issued. However, if any full stop, the interim order shall be considered on the next returnable date. This court, however, observes that if any work order is issued to the respondent number 8 in the meantime, the same shall be subject to the outcome of the petition.
All clause 2.08 1 and
No, 2 is different. 2 is on the certificate. His qualification has to be 2.1. So that is what. Yes. No, now the question arises as to whether the lands have been settled with anybody. No.
So that instruction, in fact, in between during the request period, we make an attempt, my lord, to find out. They say it will take some time to find out because they will have to verify the record.
There is already a report. The report already says that it has not been settled.
Where?
806.
No, that is where it is seen now. You see, kindly 106, as per the order of the additional deputy commissioner, passed in land sale case number so and so, an area of 250 bighas covered by Iman under so and so was settled in the name of the president and secretary Rayati so and so, who are recorded tenants of the land.
Then again,
The land has either been allotted or settled with anybody till date, nor any compensation has been paid to the entire land remains as it was at the time of initiating of the land sealing.
like in the Jamabandi also, my lord, is shown as Sarkari details.
The entire land? Yes. 500?
Yes.
Where?
Lord, takes up page 74, my lord. Just read the Asmi remark. Go.
Which one?
Go, my lord. তিনিশ চৌসত্তৰ নং চিলিং কেছৰ 7 ধাৰা মতে মহোদয়ৰ কালেক্টৰ মহোদয়ৰ ইমান তাৰিখৰ হুকুম মতে 9 নং ঋত্বিকৰাজ পাত্ৰৰ সমুদায় মাটি 158 বিঘাত 4 কঠা 18 তেঠাত মাটি চিলিং আইন মতে অধিগ্ৰহণ হোৱাত ইমান চনৰ মতপত্তিৰ পৰা বাদ দি চৰকাৰী কথা।
This is only 158.
Hello. This is concerning 9.
The thing is, if I set aside the entire ceiling as of now, and ask them to do Dino,
That is why I had pointed this.
no, Dino, wouldn't that be a problem out there if other lands have been set?
Exactly. This is precisely why I had shown, not because the acquisition ceiling proceedings have to go in any case, not because they are procedurally irregular. Over and above that, if your lordship grants them the liberty to start a de novo, my lord, may lead to double acquisition because patta number 3 apparently it has gone.
Where?
My lord, as per the report of the ADC, patta number 3 for 250 bighas have gone to some Rayati Sangram committee. So it is
No, therefore it says, that is the page. Patta number 3 has been settled. It is to be noted that neither any land has been either allotted or settled with anybody till date.
Okay.
So, whether it is only an order passed by the Deputy Commissioner, 99, but whether the Deputy Commissioner has settled, could have settled the land. Because if I can't set partly and say that the 158 be given to him.
Yeah.
On what basis do I do it? If 173 is not there, 72 is not there,
Yeah.
then how do this court take note of that?
No, because the lordship has seen, my lord, the additional chief secretary's order, my lord, whereby, my lord,
He says that it is wrong.
yeah, but, my lord, he is taking, my lord,
And the reason why that order has been passed in the review is because of the fact that he knows now the problem has gone beyond his hands.
yeah.
And as such that now he says that I cannot do anything.
Yes, it is just a
And therefore,
way of my lord, just my lord, avoiding it.
I am not doing anything. Let him go to the High Court. Whatever High Court does it.
Yeah.
That is the basis.
Yeah. Now, my lord, apparently, my lord, and evidently here, my lord, glaring irregularities has crept in. Glaring irregularities have crept in drawing up the proceeding. Statute is clear. Now, the provisions of the statute has been given a go by, which I say I must fairly admit. Now, my lord, this page number 105. Circle, my lord, this is additional deputy commissioner's report. But this is dated way back in the year 2009. From 2009 till today.
From 2009 till today, the matter has been litigated. Prior to 2009, it has been shown as sorcery of 158 has been shown as because his certificate, the certified copy which he have shown up now, shows is of the year 2009, signed on 2009. So therefore, other people may not have come in. But the fact that is 158. But how can this court only choose out 158 without going into the question of de novo thing? So therefore, one has to now find out as to whether there has been any settlement made. On this basis, it doesn't seem that there is any settlement made. But what is the meaning of this order at page 106?
Yes. 106 is a communication. It's a communication.
Understood. You see the second paragraph.
Yes, my lord.
Nine is presently with the Pattada.
Yes.
9 is under his possession.
Yes.
Then 9 how much? 9 is 180 bighas.
158.
158 bighas, 280 less.
Where do you get 158 bighas?
158 because as per the Jamapati order.
No, as per order itself, it is there in the last paragraph, my lord. Page 105 itself. Page 105, last paragraph. As per order of the collector, 5 members.
No. That I understood. That is the thing which has gone the problem out there.
My lord.
See, the collector made on the basis of that document, wherein it has been shown as 158.
Yes,
158.
158.
Whereas actually, if you see the previous order, it says 180. His application was for 180 for dark number 9.
Yes.
And he wanted another 120 for dark number 3,
Yes,
which
my lord.
makes it 300
Yes.
out of 589.
Yes.
That is it. And how does 158 come in?
Otherwise, if my lord proposes to dispose, lordship may dispose my lord by interfering with this one, and then my lord giving a liberty to
It
the
will have a cascading effect if I dispose it in this manner today.
no, my lord, what I am proposing, my lord, if my lord disposes it, my lord interfering with this ceiling, my lord proceeding, because it is no ceiling proceedings in the eye of law. Then lordship may give a liberty to the authorities to take out make a verification exercise while drawing up a my lord ceiling proceeding, de novo ceiling proceeding. They will make a verification exercise and fill inquiry, my lord, and thereafter, my lord, whatever is found to be ceiling surplus as on today, in respect of the petitioner, that may be acquired. That may be acquired. That is of course, my lord, one possible way. Because on field, my lord, inquiry has to be made. Then otherwise, if my lord is keeping this matter alive, lordship will grant us some time to get the instructions. So what is happening in the field? Because from
No, the moment I set aside,
yes, my lord.
if any patta has been issued to anybody,
Yes.
will go. Because the land will revert back to him.
Yes. Yes.
Then wouldn't it have a very big
Yes,
cascading effect?
yes, definitely. Definitely.
That is the worry.
Therefore, my lord, at this stage,
You are saying on one thing, I understand
No, no,
that I may give it, and then I may very well say one thing, you carry out the de novo, and by carrying out the de novo, any pattas which have been issued to anybody should be taken into on the ground of only on the ceiling surplus and only on the ceiling surplus, and remaining which he is entitled to shall be given back to him. That is one what you are saying.
one way.
One way.
Yes.
But can the direction be given to de novo without setting aside that?
No. If it is de novo, then this has to be set aside. But it appears, my lord, that nothing has progressed, my lord, because
No,
statement
one
was-
progress you can very well make it. See, tag number, NK Patta number 3 and 9 and 2. We are concerned with 2 had only 6 figures. 9 had 180 figures. That is what see.
I had said. My predecessor had said in their application.
Yes, 180. And then there is another 310 figures out there in the other.
Yes. Total comes to 560.
516 or 589 actually.
Yes, 589. Yes.
But that is why 560 has been taken, and thereby he has been now given 158. This is how it has happened.
Yes.
Let me just point out one thing. So far as Patna
That could have one my lord, the exchange, my lord, I would precisely say, my lord, 158 because that also could not happen, my lord, in view of 50 because my lord, upper capping limit here. How 158 because have been given to one family, one person. Because because 56 Act says, my lord, it will be only, my lord, 50 because for any type of land, 7 except tea land. But for tea cultivation, my lord, there is no upper capping limit.
Because how did he have so much of land? Means how did he get so much of land?
It's a mysterious patta, my lord.
What mysterious patta?
Sorry,
Very easy to
NK,
say
my lord,
very mysterious patta.
not, my lord. It is NK, my lord, is a non-cadastral. So perhaps, my lord, it was not surveyed, my lord. At that point of
But then also, it was not surveyed, but then also.
And my lord will come through
Feeling
section
holding, notwithstanding anything in the contrary to law custom, agreement, no person shall be entitled to hold as owner or tenant or mortgage or land within which exceeds the limit of 50 bighas in the aggregate, and this limit of 50 bighas shall be the aggregate of the land held individually by the members of the family or jointly by some or all members of provided by the person who
Family is different.
Huh?
Family is defined in
Where?
3D.
3B
3D. Family and joint.
means a family consisting of the following husband, wife, children. So this is similar to that your land policy. So therefore, once he's married, you can't bring him. He would not come within the. Therefore, he will be entitled.
That is the one thing. Today we are activating our.
Now, can we ask for a notional step be taken by the authority, and on the basis of which we can do it? Notion or notion. It will be taken up on the basis of this. An exercise be carried. And then
Yes, that's what otherwise.
then in that regard, it will also be found out as to where this land, which is land, which is.
Yes, definitely.
And thereupon, if that is being done, that will be till 7-2. And that report, once that statement is being prepared on the 7-2, he gets an objection to the report. You submit the report before this court. And on the basis, he may submit his objection to that effect to the authorities. Till there, I can give it. And not the 7-3 being.
Yes, possible, but
See, then in that regard, it can be closed out there and it can be regularized without disturbing anybody.
otherwise, if lordship wishes to, my lord, find out the present status of this, because these patta numbers are there.
From the patta, you can very well find out.
Yes, now these patta numbers by passage of time might have been, my lord, bifurcated or something has been changed. Lordship may direct
The thing would have happened now. You see, in a recent settlement period, Talukbari Muta came under the settlement.
Yes.
So now NK3 and NK9 is not there. But from the map, it can very well be traced out as to what has happened to 3 and 9.
No, but therefore, Lord, because 3 and 9 is stood as at that point of time. Now 3 and 9 by passage of time might have changed everything. They are on papers, it might have changed, on field also it might have changed.
Not only that, another important aspect would have been there are recorded tenants.
Therefore,
so these recorded, because it will bring another very important aspect. Once the recorded tenants may have also applied for occupancy right.
Yes.
So if I may just clarify one thing. We in this writ petition, we are only concerned with patta number 9. We are not staking our claim for 3N. We have said that we believe that 9 was our retainable portion, rest of it has gone. Now till 2009, Jamapundi, it is shown as Sorkari. Then, Manoj, there's a report of the ADC which is also clear that no settlement has been carried out. 2012, the writ petition was disposed of. Thereafter, Manoj, this entire process of review, the 7-6 appeal had gone on. Thereafter, when we filed this petition, we got a stay order, So, and we've made a statement on record that there has been no settlement so far. So, insofar as 9 is concerned, 9 is still in our possession, 9 is still Sarkari, and there has been no settlement. Now, so if I may suggest, so far as the acquisition, insofar as it relates to 9 is concerned, if that is set aside, then my names are reverted back to the record of right. Thereafter, my lord, if your lordship contemplates on giving them a liberty for a de novo acquisition, then they will take into account how much of patta number 3 has been settled or made Sarkari, and then the calculations can come up. Because admitted, apparently I'm entitled to 5 plus 5 into 50, that is 250 bigger. 250 because I was already allowed to retain. Now that retainable portion of 250 as per the finance statement was there in Patta number 3. Patta number 3 according to the ADC's report again has been 250 because has been settled with the Pangram committee. Now so far as 9 is concerned, that should
No, apparently has been settled means where it is settled. There is nothing on record. No, the report says that ADC has passed an order, but then the next paragraph categorically says that there has been no allotment.
No, that in my understanding, the second last paragraph is in reference to Patta number 9.
It would be better if my lord calls for a complete status report from the office of the deputy commissioner, now with regard to all these pattas. Whatever is there, let everything be placed on because land now, because we are unable to now produce the land ceiling proceeding, but the revenue records are still there. Land ceiling proceedings is an offshoot of the entire revenue record. So Lordship will call for the entire.
Once we get the hold of that, so therefore I was saying.
Lordship will also call for for assistance of this court, any officer, the ADC revenue will be competent, he will bring all the records, he will explain, Let us be clear on the point, He is only making statement, it's a statement that it is not settled, it is not corroborated with record, with all due respect, He is making this statement, it is a part of pleadings. Lordship is exercising his jurisdiction under 226, Court of Record. So Lordship will very much like to go through the record, There is no hide and seek. We will place it, the revenue record, the entire revenue record pertaining to this purpose. Lordship will make an observation, what are the requirements, We will communicate, to the authorities, We will get the record, and if the person is deputed, it will be beneficial for all of us. This is the
They can very well give a report to the
report, and also if initially Lordship may call for a report. If Lordship is not satisfied with the report and further explanation, Lordship will call for or the original records, and also call for
first of all, as regards NK Patta number 3, 2, 3, and 9.
Yes.
You're not concerned with 2. 3 and 9.
My lord, I'm not even speaking of 3. As of now, 3, I'm not even speaking.
Don't say that. See, why you are to 9 only? I understand you are saying about 9 because 9 is vacant and you are in possession. That is the reason why you are saying 9 you are saying out there. But I understand that. But the problem which will otherwise arise is how would this court? Yes, if you want, I can very well dispose of this instant petition, directing them to consider that this is not properly done. But this will have this is not going to give you an answer. You are not going to get this 158.
Because
this court can't give you 158 unless this court holds that yes, there was a mistake on the part of them, and as such there is no 72 or 73. This court has to hold it. If this court has to hold 72 and 73, or there has been no compliance to 72 or 73, then the entire
proceeding
goes. Understand, if the entire proceeding goes, then 589 bigas comes into the floor again. And once this court is not going to sit out here as the chief secretary out here or the additional chief secretary. It is for the revenue department to prove it.
What I'm submitting is what my friend is suggesting that the report be called for. 3 affidavits have been filed. There's absolutely nothing. Now,
okay. Let them file the affidavit, but it was not pinpointed out in this manner. Now, therefore, I have asked Mr. Borputari that one needs to find out what is the status of after the settlement proceedings.
Yeah.
Now the settlement proceedings, because 2009 the settlement proceedings was not over. So thereupon now NK3 and NK9 has now become different. There might be different dark, different patterns which has happened out there. Now what has happened? They might be putting out there in a particular dark, and now they will be making a dark of the government, the entire land. Now, if we can now find out yes, this is a government plot of land which is there, it would be easier for this court to pass, mold the relief and give you.
Yes. Because
No, my lord,
by that time,
my lord, ultimately, if that, my lord, 9, Patna number 9, number 9 is, my lord, 9, apparently there has been no settlement, there was no compensation paid, it is the stand of the revenue officer that there was no compensation, that there was no settlement.
How do we know today?
My lord, going,
It is in 2009. Let us.
my lord, after 2009, nothing could have transpired, my lord, because these proceedings were pending and eventually there was a stay.
They came in 2020, 2009.
And before that, my lord, there's already the report. And the Jamabandi also shows.
The report is of 2009.
2009, correct.
Then thereafter, from 2009 to 2020, what has happened in the meantime? You approached in the year 2020, you got a stay then. Not prior to that.
2012 also, my lord, when I had approached, my lord, when they had considered the chief secretary's order doesn't reflect that it was ever settled, my lord. In fact, it has said that there was no compensation, nothing, my lord. Even the final statement was not prepared. Now, my lord, the process that your lordship is contemplating, my lord, now it will be a never-ending process, my lord. Because all your lordship has to see whether 300A has been violated or not. Now, if the acquisition proceedings are sealing
So
proceedings,
if the moment I bring in say 300A,
my lord,
then the entire sealing proceeding
goes, ma'am. Sealing proceeding goes.
So once the sealing proceeding goes, then what happens?
Patna number 9 reverts back to me, ma'am.
Not only Patna number 9, Patna number 3 also comes back to you.
Patna number 3, my lord, I'm not agitating, my lord.
Isn't it one sealing proceeding?
one.
How can I bifurcate? Okay, because Mr. Burundeka only wants 9, I am giving him 9.
That is the difficulty.
My lord,
That is
therefore,
what I
my
am
lord, your
submitting
lordship
again
has
and
already said if they start de novo, that they take into account how much of it, if it has gone, how much of it has gone. And then if they feel that they can start de novo with having to
that difficulties authorities may start a de novo proceedings. We are not averse to that. Problem lies, my lord, from 2009 till now. My lord, the patras might have, maybe may not be. We do not know.
No, patras have changed. In
Therefore, yes, now,
they
my lord,
cannot be the same
no,
patras.
my lord, my apprehension is that, my lord, there will be persons who will be affected by this order.
That is what I'm saying. Because once the moment I applied 300A, the
I am
entire
not concerned
proceedings
with him
goes.
right now. I am concerned with, my lord, the other person. Now they will lose their valuable right. That is the difficulty. He has a genuine case on merit, my lord, so far as, my lord, the procedure is concerned, my lord. We are nobody to, my lord, make a formidable defense. But there are other people, my lord, who will be affected. That is the difficulty. If by now, my lord, some pattas have been issued, settlement has been made. So Chief has passed so many decisions in the meantime. One settlement is made, my lord, it cannot be cancelled. They will have an opportunity of being heard. Therefore, my lord, it is their duty to being on record. That now, as of now, this is the position. It is their duty.
Lord, may kindly refer to their affidavit.
Affidavit, my lord, that is nowhere. This is circle officer report, my lord. This is absolutely, my lord.
My lord, pleadings are complete. The matter is fixed on hearing, my lord. The affidavits have been filed so far, and now they say they'll get a report and resolve everything. My lord, will kindly have the affidavit filed by Avlokanon domain.
Yes.
Page 176 onward, my lord.
What does he say?
180, page 180, if your lordship takes up.
He doesn't say anything.
He says on the
additional affidavit. Additional affidavit filed by
My lord,
on number 1.
yes, my lord, by the
One?
Respondent number 1.
180.
180. My lord, he's talked about the spot investigation.
This is dated 9. That is what.
Throughout, there has been no statement that there could have possibly been a settlement.
This is the one which we have been reading all along. This is the land. This is the document which is there at page 106.
This is the report on the basis of which there was 106.
No, this is the 106. As a result of the order of the so and so, the 250 vigas the involved in here was named in the so and so was included in the name. Now see, involved in the auction of Tiraspeta Barnaby Air was included in the name of so and so.
Yes.
Pattada. Of auction Korida Patra.
Oh, Korida Putra Patra. The entire land of this patta is found to have recorded rights.
Now,
land involved.
No. Therefore, this land has been given as Korida Patra. Has this land gone on auction sale?
Perhaps, my lord.
But this is contrary to what has been stated there
Yes.
by the circle officer.
Yes.
Now, who has given this report?
This report is, my lord, from the circle officer.
This is the very. Now, what does it say in this report?
105 and 6 is ATC.
Huh?
105 and 6 is ATC.
Now 105 and 6 is of 512.
Yes.
Now here he says, as per the order of ATM so and so, this is the order which is referring at page
182.
Yes.
84, 27.
Yes.
So and so, covered by Iman of Tilane was settled. Now here he uses the word settled. And on the other hand, it is included in the name of the president so and so at the site of 250 because Korida auction Korida Putra Patada. Auction means there is an auction sale. What is this document? This document is again, no land in this sealing case has so far been allotted or patta.
Patta in the name of any
individual or event. So in this sealing case, the sealing case has 3 and 9. According to the records in this office, the pattatas are not seen to be compensated for. According to the sealing case of the 3 pattas, so and so remains in the same status as it was before the acquisition, meaning thereby that it remains the same. No patta has been issued. No, this is of 2009. So what has happened now?
He has only reiterated, therefore this affidavit is incomplete, my lord.
But again, he has said something unnecessary, some option that seems to be different from what it is.
This is a translation of, my lord, at page 186. Page 186 is there, my lord. It is a report, my lord, from the circle officer. From the circle officer to the additional deputy commissioner.
What does it say?
My lord, if I may read it, my lord.
Dated what?
It is 16/11/2009.
So this is after that, but this is prior to that ADC's communication.
Yes.
ADC is 1512.
Yes. If I may read it, my lord, that page 186, my lord, the vernacular. 4, 5, 6, 7, 8 and 9 চিলিংগুছৰ নম্বৰ 70-76 সন্দৰ্ভত তলত দিয়া ধৰণে প্ৰতিবেদন প্ৰস্তুত কৰি মহোদয়ক জনাও যে সমাহৰ্তাৰ 1976 হুকুম মৰ্মে পট্টাগণৰ মুঠ 560 বিঘা 2 কঠা 8 লেচা জমিৰ পৰা প্ৰতিজন পট্টাদাৰৰ নামত 50 বিঘা গৈ মুঠ 5 জন পট্টাদাৰৰ 250 বিঘা মাটি পট্টাত বাহাল ৰাখি 310 বিঘা 2 কঠা 8 লেচা জমি 1975 চনৰ সংশোধিত চিলিং আইন মতে অধিগ্ৰহণ কৰা হয়। উক্ত হুকুমত বাৰী বস্তি অৰ্চাৰ্ডৰ বাবে প্ৰত্যেকৰ নামত চিলিং আইন মতে 4 বিঘাকৈ জমি ৰাখিব পৰা জমিৰ বিষয়ে বিবেচনা কৰা হোৱা নাই। প্ৰকাশ থাকে যে পট্টাদাৰগণৰ কোনো গাঁৱত কোনো পট্টাত কোনো ডাঙৰ পৰা কিমান পৰিমাণৰ মাটি চিলিং অধিগ্ৰহণ কৰা হ'ব আৰু কোন গাঁৱত কোন পট্টাত কোন ডাগৰ পৰা কিমান মাটি তেওঁলোকক ৰাখিবলৈ দিয়া হ'ব সেই বিষয়ে উল্লেখ থকা দেখা নাযায়। ঠিক সেইদৰে চূড়ান্ত বিৱৰণীখন কোন গাঁৱত কোন পট্টা কোন ডাগৰ কিমান মাটি অধিগ্ৰহণ হ'ল বা কিমান মাটি পট্টাদাৰক ৰাখিব দিব পৰা হ'ল তাৰ বিস্তৃত বিৱৰণী প্ৰকাশ দেখা নাযায়।
No, another thing is, if the matter was placed before the revenue secretary, because the revenue was the appellate court, you will have a copy.
He will not have the copy of it.
Why not? He was dealing with a appeal.
But that has been my lord disposed.
Maybe, but you may be having it. They will have a record.
It's very difficult to find.
It may be lying with him.
No, I can make an attempt, my lord.
But you will have the record. Because you see, an appeal was filed by him. When an appeal is filed, normally records are copied. The appeal was dismissed on the ground of delay. Then he filed a petition. Then the order was then it was duly the additional chief secretary passed an order, and he passed an order on the basis of record.
Yep.
He did, and then, but later on the additional chief secretary said there's no review, nothing.
Therefore, Lord, it is still, my lord, put record at that point of time.
Yes, the deputy commissioner may not have the record.
No, but
the revenue department may.
No, revenue department will have, if we take it also, we'll have the records, my lord, of that time. But we are now concerned as Lordship has.
No, that we will look at.
Yes.
That is another. These orders that the task of the affidavit was for sitting.
Yes.
The records may not be there. The last affidavit which we have filed
yes.
is in respect to the ceiling case.
Yes.
Now there you are saying that you may not have the record.
Yes.
The district administration does not have.
Yes.
But the revenue may have because the appeal was pending before the revenue. Because how did the additional chief secretary pass so many orders?
Let me go through it, my lord. Because whether records have been perused, my lord, let me see, my lord. There is a specific...
Today I have given you a lot of time because of the fact I have no other matters.
No, that's true. No, but here, my lord, what is disturbing is, my lord, this my lord, circle officer's report in vernacular, my lord. This translation is also not correct. Therefore, I am reading the vernacular. Page 187 it is seen, my lord. Sarojabin Todonto pa dekha jai.
Where page?
Page 187. It is a part of that additional affidavit. It starts from 186. Page 186, it is stated, my lord, that there are all irregularities. Then 187, ইয়াৰ পিছত 16/6/81 ইংৰাজী কামৰূপ জিলা উপায়ুক্ত মহোদয়ৰ তাৰিখৰ মেমো চিঠি হুকুম মৰ্মে লাটমণ্ডল তথা চলেমান আলী সিন্দুৰীগোপাৰ গাঁৱৰ 3 নম্বৰ খেৰাজ পট্টাৰ আৰু বুলতাৰী গাঁৱৰ জমি দখল চমজি লয়। সেই একেদিনাই মণ্ডল চাজাহান আলীয়ে চিলা সিন্দুৰীগোপী মৌজাৰ নিজ সিন্দুৰীগোপা গাঁৱৰ 9 নম্বৰ খেৰাজ পট্টাৰ 158 বিঘা 2 কঠা 18 লেচা জমি দখল চমজি লয়। Then it is now this is important. সৰজমিন তদন্তৰ পৰা দেখা যায় যে নিজ সিন্দুৰীগোপা গাঁৱৰ 9 নম্বৰ খেৰাজ পট্টাৰ 158 বিঘা 3 কঠা 18 লেচা জমি পট্টাদাৰ তথা ৰায়তৰ দখলত আছে বা ৰাখিছে। আনহাতে উক্ত মৌজাৰ গাঁৱৰ 3 নম্বৰ খেৰাজ পট্টাৰ ধূপকাৰী গাঁৱৰ 2 নম্বৰ 3 নম্বৰ খেৰাজ পট্টাৰ জমিত পট্টাদাৰৰ দখল থকা দেখা নাযায়। So they don't have possession.
Well, then that is also why the reason is also given. See,
পট্টাদাৰ গণে কোৱা মৰ্মে তেওঁলোকে বনমৌজা গাঁৱৰ 3 নম্বৰ খেৰাজ পট্টাৰ সমুদায় জমি চিলিং আইনমতে অধিগ্ৰহণ হোৱা বুলি ভাবি উক্ত জমিত দখল কৰা নাই আৰু উক্ত জমিৰ খাজানা আদিও দিয়া দেখা নাযায়। দখল সন্ধি
So
লোৱা
there, whether there was an auction sale,
that again my lord will have to verify.
unless it has been made sorkari.
Yes, on sorry. An auction sale will be a fallout of section 17. Section 17. Because 16 landless persons and government may settle it. 17 is if nobody is found, then it will be settled with other persons. So 16 and 17 are not mutually inclusive, they are exclusive. এক মিনিট ইয়াৰ ফলত yes মানে it is there. পট্টাগণে কোৱা মৰ্মে তেওঁলোকে দেখা নাযায়, দখল কৰা নাই। দখল সন্ধি লোৱা প্ৰতিবেদনৰ কপি পট্টাদাৰক দিয়া হৈছে নে নাই সেই বিষয়ে এই কাৰ্যালয়ত কোনো ৰেকৰ্ড থকা দেখা নাযায়। ইয়াৰ ফলত 62/87 নম্বৰ নিলাম গোচৰৰ 2799 ইংৰাজী তাৰিখৰ অতিৰিক্ত উপায়ুক্ত মহোদয়ৰ হুকুম মৰ্মে বনমজা গাঁৱৰ 3 নম্বৰ খেৰাজ পট্টাৰ সমুদায় 250 বিঘা জমিত নিলাম খৰিদাৰ সূত্ৰে পট্টাদাৰ গণৰ স্থলত সভাপতি সম্পাদক ৰায়তী সংগ্ৰাম সমিতিৰ নাম অন্তৰ্ভুক্ত কৰা হয়। So section 17 has been applied.
Section 17 is nilam. How are you doing the auction? That is a settlement.
Settlement. How is it?
No, they have not resorted there. They went to 74 of the Assam Land and Revenue Regulation.
Yes. It has gone there.
And that to no issue notice.
Well, everything has gone for a toss there.
And that is why the moment it came out there, I thought about it. Because they are not paying land revenue means they otherwise he is not going to write there.
Not getting any hidden cash here. Somehow I am comprehending my lord. Comprehending. How
Then in that case, Mr. Borpujari.
One paragraph is there. এই চিলিং গোচৰৰ অন্তৰ্ভুক্ত কোনো জমি এতিয়ালৈকে কোনো ব্যক্তি বা অনুষ্ঠান প্ৰতিষ্ঠানৰ নামত আবণ্টন বা পট্টা দিয়া দেখা নাযায়।
Understood. This is the last part everywhere.
Yes, everywhere.
Now here he says this.
Yes.
Auction. And this is what you have transferred. But the ADC says settlement.
ADC says settlement, yes.
See, that is the
Yes,
difference.
yes,
What I am saying.
Yes.
But
Auction and
here
settlement-
there is a reference to a Nilam Gusor.
Yes, because-
Means this has been sold
yes,
on account of
yes,
non-payment of revenue.
Yes. Non-payment of revenue.
So ADC's report of 15/12/2009 also may not be the correct thing.
Yes. So my lord, the land record as it stands as on today with regard to all these pattas. Maybe patta number has changed, but this is the enough. All these pattas, the chief may call for a status report as with documents, supporting documents. Let us give a status
Then
report.
if we don't find anywhere any possibility,
Yes.
then I think 158 bighas which is there in their possession, at least that needs to be given.
Definitely. No, because this entire
No, then I have to hold it. That everything has gone for a 6. So under such circular, 158 bighas has to be given.
Even today also lordship can dispose it, my lord, we cannot defend. But the difficulty is that, my lord, it may, my lord, it may cause adverse effect to the persons, my lord, who might have been settled. That is the difficulty. Because from 2009, or for that matter from 2012 till today, within this span of 10 years, we do not know what has transpired. There is no material on record. That is the difficulty. That is my apprehension. Otherwise, my lord, admittedly, my lord, the ceiling proceedings, my lord, statutory norms have not been followed. How can I defend, my lord? The admitted position, my lord. That is the only difficulty. And therefore, my lord, if somebody is a necessary party, is their burden. to complete them, to find out.
Provided they show that they have settled,
No, no,
Manoj.
yeah.
Settlement is in their domain, Manoj.
Because
Now
somewhere
they are
it's a
guessing.
No,
somewhere
if there he has been stealing, then first of all, if the land has already been acquired,
Yes.
can you go for the selling it? It will have again a disastrous consequence. The auction sale.
yes, no, auction sale cannot be. But auction sale, what has because
No,
here,
what has happened out here is it has been shown that 250 bighas have been retained by them.
yes, but the
At
thing,
quota number 3,
yes,
and they have not paid, so they have gone for the land auction.
yes. So a land auction might be maybe for the reason here in the circle officer's report, my lord, I have just now read that they were not aware of that they had surplus, my lord, so many lands. They were not aware about that land. They could not pay land revenue.
No,
No, we were aware. We made that
no, not that. It's something like this. See, total 589 bighas or 560 would have happened out there.
Yes.
They wanted to retain this 158
My lord.
of the pata number 9.
Yes.
So 158 was made sarkar.
Yes.
And some other 120 bighas of
Yes.
Dr. Nariman.
Yes.
Remaining 250 was given to them.
My lord.
Okay?
To them.
As per 7.3
Yes.
or whatever maybe
Yes,
they say.
55%.
Yes.
25,
So,
yes.
so 250 was given.
My
Now,
lord.
250 was given in pata number 3.
My lord.
Now, pata number 3, when 250 was given, they did not pay the revenue. So they have gone for auction sale.
Yes. That is a possibility because what
That
I find,
seems to be the only
yeah,
thing.
that seems to be the possibility. Therefore, I was reading this report.
Here, their question is, we wanted 158 only. And pata number 9, as such, we are possessing this. We don't know anything about dark number 3.
So
That
how
is
would
why
we
he
know
is
if we don't-
insisting, only don't go to dark number 3.
And how would we know, Manoj, if there is no possibility?
So therefore, my lord, with regard to all these pattas, let us have the record of right at least Siddharth. Let us have the Siddharth and as well as my lord, the record of right Jamabandi. So you can take a call for that.
This court, on hearing the learned counsels for the part, is of the opinion that in order to come to a effective, come to a decision in the instant matter, a report from the Deputy Commissioner, Kamrup, rural, would be required. As regards the status of the land of NK Patta number 3, as well as NK Patta number 9
Yes.
of village,
Village Nish Senduri Gupa,
3 is Bonmoja.
Bonmoja.
3 is Bonmoja.
of NK Patta number 3 pertaining to village,
Bonmoja.
Bonmoja.
Bonmoja, and NK Patta number 9
Nish Sinduri.
pertaining to village number 7, both in the district of, located in the district of Kamrup Metro, Kamrup rural, along with all our documents pertaining to the all other revenue records in respect to the said 2 pattas, and also indicate in the said report certified copy of the revenue report, and also indicate in the said report as to any changes had happened in respect to the said pattas in number, pattas in question, NK pattas in question, pursuant to the pursuant to the settlement operation concluded in respect to the Jalukbari Moja. This is Jalukbari Moja.
No, Silas, it is not Guwahati Revenue Circle. Jalukbari falls under Kamrup Metro.
No, in which Moja? The both lands are in Silasundu.
No, yes, both lands are Nish Silasenduri Gupa.
In respect to, but whether there was a settlement operation done in that case.
My lord, that, my lord, we have to, my lord, it will be revealed, my lord, from the present revenue.
Then there was no settlement.
May not be, my lord.
So he lied to the side.
And the revenue circle will be Lordship will kindly indicate, my lord, it is not Guwahati revenue circle. Not Guwahati
Only
revenue
within
circle.
North Guwahati.
Revenue circle.
खाली हे last. It's the matter. How much time?
Lordship will kindly give me at least 2 to 3 weeks time, my lord.
It's the matter on 15th of 15th.
As a part of matter.
The top of the
As a part of.
Yes,
the matter having been heard at length, be shown it.
So, my lord, so
So this is the matter why I've been thinking.
embarrassing on our part, my lord.
Huh?
It's very embarrassing to, my lord, defend this kind of thing.
No, in fact, you get a more, get some time to also concentrate. No, other days you don't get any time at all.
Yes, yes, my lord, yes. Yes.
You are always in, I mean, so Monday, Wednesday, and Friday, you are absolutely drained out. You can't think about that. For nowadays,
Yes, yes.
give a very patient hearing to everyone.
So obliged to my lord. We line, my lord. Obliged.